Yeah, Zach. Okay.
Thanks, Allie.
No problem.
Government spending at its finest. Well, I'd rather spend money on a Democrat. See the thing with the Democrat? The member of Congress. I heard someone say, well, oh, it's almost worse than I made all the copies, and then she told me she already had.
Yeah, but we can get back from this and stuff.
Yeah, if we can, because
Is it here?
it's
The last email that Monica sent, that one,
Okay.
they do like the questions and everything before. He's got questions.
no one has it.
Got it. Well, if we need to,
Just give
you will know.
Yes.
I put them there. I won't.
Ready?
Yep.
Waiting for you.
Good morning. The Judiciary Committee will come to order, and without objection, the chair is authorized to declare recess at any time. I'd like to take a moment before we begin our markup today to honor a very special member of my staff. Barak Govinsoiler, at the age of 30, lost his courageous battle with cancer this past weekend. Barak was a valued member of the Judiciary Committee team and worked on a variety of issues, including digital privacy and intellectual property. His vast knowledge and grasp of the issues impacting the technology community was a tremendous asset to the committee. Most recently, Barak's work included the development of the committee's innovation agenda, and his steadfast work and tenacious attitude were not only essential to making this initiative a success, but were also a testament to his character. In fact, while he was undergoing intensive cancer treatments, he was aggressively working and sending follow-up emails from his hospital bed. Barak was a true technology policy enthusiast. Prior to joining the staff of the Judiciary Committee, he served as a legislative advisor for Congressman Randy Forbes. While working for Congressman Forbes, Barak handled the diverse range of issues that fall under the jurisdiction of the Judiciary Committee, but it was always evident that technology policy was his true passion. He co-founded the Congressional Tech Staff Association and served as an executive officer responsible for the professional development program. Prior to his career on Capitol Hill, Barak worked at Tech America and CompTIA, focusing on international trade policy. Barak has many friends here in the halls of Congress on both sides of the aisle. I know all of you join me in extending our deepest sympathies to his mother, Feliz Govinsoiler, and his sister, Aylin Forbes, and all of his loved ones. Barak will be deeply missed. I'd now like to recognize the ranking member, Mr. Conyers.
Thank you, Chairman Goodlatte. On behalf of all of us on this side of the aisle, I'd like to begin this hearing by offering my condolences to the family, friends, and co-workers of Barak Govinsoiler. During his service in the House of Representatives, Mr. Barak worked for Representative Randy Forbes of Virginia on technology and other issues. I have heard of the profound impact that he had on those who spent time with him, and he was a great friend, possessed a brilliant mind, and I sincerely join with my colleagues in offering my condolences to his friends and family. Thank you.
I think it would be appropriate if we had a moment of silence for Barak. Thank you.
Thank you.
Pursuant to notice, I now call up H.R. 1973 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 1973, to prevent the sexual abuse of minors and amateur athletes by requiring the prompt reporting of sexual abuse to law enforcement authorities, and for other purposes.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. Protecting the amateur athletes who represent the United States in competitions throughout the world is vitally important to the Judiciary Committee. These athletes are overseen by national governing bodies such as USA Swimming and USA Gymnastics, which were chartered by the U.S. Olympic Committee. One of the greatest challenges facing these governing bodies is preventing the sexual abuse of the athletes they support. According to a recent study, over the past 20 years, up to 368 amateur athletes were subjected to sexual abuse by adults affiliated with one governing body, USA Gymnastics. The Protecting Young Victims from Sexual Abuse Act addresses the problem of abuse within amateur athletics. The act implements changes to reporting requirements, strengthens civil remedies for victims of abuse, and clarifies the duties of national governing bodies in handling allegations of abuse. The bill first establishes a reporting requirement, which includes a penalty for failing to report sexual abuse of the athletes. It also broadens the scope of individuals covered under mandatory reporting to include coaches, team doctors, or any adult authorized by a national governing body to interact with children. These are the same requirements imposed on other professionals and those who are in a unique position to observe abuse or evidence of abuse, such as nurses, teachers, and even film developers. Additionally, the Act bolsters civil remedy options for amateur athletes who are victims of sexual abuse. The provision clarifies that a victim of sexual abuse need not prove personal monetary injury of $150,000 when they sue their abuser. The Act also allows for a court to award punitive damages to victims when warranted. Furthermore, the bill specifies that national governing bodies are authorized to develop and implement training, oversight practices, and safety procedures with the goal of ending sexual abuse within amateur athletics. The bill was introduced by Congresswoman Susan Brooks in the House with bipartisan support, and I urge my colleagues to support H.R. 1973. It's now my pleasure to recognize the ranking member of the committee, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. I support H.R. 1973, the Protecting Young Victims from Sexual Abuse, for several reasons. Most importantly, this is a reasonable and important measure that is intended to help protect young athletes from abuse and preserve the sanctity of sports associated with the United States Olympic Committee, the organization responsible for preparing and training young athletes who might one day represent their country competitively all over the world. Children deserve to fully enjoy the innocence of their youth by exploring the curiosities of the world, taking pleasure in the arts, and participating in sports, free from betrayal, harm, or danger. Involvement in sports and instruction and guidance from adult coaches can positively influence young people's growth and development and their potential for future success into adulthood. The sexual abuse of children and youth is intolerable in any context, and we must take appropriate measures to eliminate it from youth sports. Such exploitation betrays and harms young people, sometimes severely and irreparably. Young people look to adults to protect them and keep them safe. We all have a responsibility to do so. With H.R. 1973, we have the opportunity to ensure that individuals abide by this duty. Existing federal law requires certain professionals, such as doctors, dentists, social workers, psychologists, teachers, and daycare workers who regularly interact with children to report suspected abuse to law enforcement. While our discussion of this legislation today may focus primarily on sexual abuse, H.R. 1973 will require adults who interact with young athletes in connection to national governing bodies of various sports to report suspected abuse of any kind. The need for this legislation is best illustrated by an ongoing scandal of widespread abuse and exploitation of young gymnasts over the course of 20 years within the USA Gymnastics, a prominent governing body of the United States Olympic Committee. Many complaints of sexual and emotional abuse went unreported, allowing coaches, instructors, and doctors to repeatedly victimize gymnasts as young as 6 years old. The shocking failure of anyone to report accusations to law enforcement or even keep track of them internally made it possible for some of these predators to commit horrific acts at several gyms in several states. For example, a cloud of allegations of abuse surrounded one particular physician as far back as 1997. He was on the faculty, I'm sorry to say, of Michigan State University, worked with the Spartan gymnastic team, and provided volunteer services to USA Gymnastics for many years. Regrettably, allegations against him were not reported to law enforcement until recently. Now, following the first public complaint in 2015, more than 100 women have filed complaints accusing him of sexual abuse, and he faces more than 20 criminal charges in federal and state courts as well. While the USA Gymnastics scandal is unfortunate, let it be an example, an incentive to prevent such pervasive abuse elsewhere. And so I thank Chairman Goodlatte for his leadership on this important legislation, which I support, and encourage my colleagues to do the same. I thank you.
I thank the gentleman, and I now recognize myself for purposes of offering an amendment. The clerk will report the amendment.
Amendment to H.R. 1973 offered by Mr. Goodlatte. Page 2,
Without
strike line
objection, the
15.
amendment will be considered as read, and I recognize myself to explain the amendment. This manager's amendment makes a series of small changes in the bill, most of which are intended to merely clarify certain provisions. Substantively, the amendment adds one necessary word to the civil liability portion of the bill. Currently, the tolling provision in the civil liability provision provides a subjective standard in which a civil lawsuit can be brought within 10 years of a plaintiff's own subjective statement of injury, which could occur decades later, whether or not such injury should have been reasonably discovered earlier and before witnesses died and other relevant evidence was destroyed. And so under my amendment, at page 5, line 7, the term reasonably is inserted before discovers. Applying a reasonableness standard to statutes of limitations is fair and commonplace. The official notes that 18 U.S.C.A. section 2255 itself, which the base bill amends, in the U.S. Code specifically refer to the case of Singleton versus Clash, in which the court made clear that the discovery rule provides that the clock begins to run when the plaintiff has inquiry notice of his injury, namely when he discovers or reasonably should have discovered the injury. The court went on to say that under the discovery rule, the inquiry is when the plaintiff knew or reasonably should have known of the injury. As the court made clear, statutes of limitations are intended to promote justice by preventing surprises through the revival of claims that have been allowed to slumber until evidence has been lost, memories have faded, and witnesses have disappeared. And as the Supreme Court wrote in United States versus Kubrick, relied on by the court in Singleton, a plaintiff armed with the facts about the harm done to him can protect himself by seeking advice in the medical and legal community. To excuse him from promptly doing so by postponing the accrual of his claim would undermine the purpose of the limitation statute. As the court further stated in Singleton versus Clash, the plaintiff's theory would allow Section 2255 claims decades beyond when the violation occurred. The base bill would codify that theory as a matter of statutory law and allow lawsuits to be filed decades after the violations accrued, which would undermine the very purpose of statutes of limitations and deter injured victims from acting promptly to alleviate their injuries, while also subjecting the accused to the unfairness of having to defend oneself perhaps decades after exonerating material evidence has disappeared. Additionally, the amendment acknowledges that the duties of a national governing organization includes cooperating with an entity designated by the U.S. Olympic Committee. This provision refers to the U.S. Center for Safe Sport, a nonprofit corporation launched in March, specifically tasked with investigating and resolving abuse allegations for national governing bodies. The original bill required national governing bodies to impose procedures to prevent one-on-one situations that are not observable and interruptible by another adult. The amendment changes this provision to instruct adults who are not the parent of the athlete to avoid one-on-one interactions. This change, while forcefully encouraging national governing bodies to implement these procedures, minimally eases the provision for sports and localities where such a procedure may be overly burdensome. The original bill called for regular and random audits to make sure national governing bodies are strictly following the rules imposed by the bill. The amendment clarifies the audits shouldn't exceed one per year. The bill allowed national governing bodies to prevent someone with a pending sexual misconduct allegation from continuing to work with kids until there was no risk to the kids. The amendment changes the no risk language to until the resolution of such sexual misconduct allegation. Additionally, if a national governing body, the U.S. Olympic Committee, or Safe Sport undertakes an interim measure under this provision, the amendment provides those entities with limited liability in those circumstances. The U.S. Olympic Committee currently may review the certification of national governing bodies under the Ted Stevens Act. The amendment mandates such reviews. This amendment reflects the practice of the U.S. Olympic Committee in reviewing national governing body certifications. These changes are small but important to assuring that our young athletes are protected from abuse and that the newly established Safe Sport is as effective as possible. I urge my colleagues to support this amendment.
Mr. Chairman,
For purposes, the gentleman from Michigan seek recognition.
to support the amendment,
Gentleman is recognized.
I'm pleased to support this amendment, which updates the language of the bill to conform with the structure of national governing bodies and their membership, and allows some flexibility in policies required to prevent abuse. And that's my brief support.
Chair thanks the gentleman. For purposes, the gentleman from New York seek recognition.
I ask, Mr. Chairman, strike last word, I suppose. I want clarification.
recognized.
Could you please explain briefly the change in the statute of limitations? What is the current statute? What would the original bill do, and what would the amendment do? I was a little confused.
I can read you again the lengthy description. Currently, the tolling provision in the civil liability provision provides a subjective standard in which a civil lawsuit can be brought within 10 years of a plaintiff's own subjective statement of injury, which could occur decades later,
Okay,
whether
that's
or
the
not
current law.
such injury should have been. It's what's provided for in this bill.
That's the bill, okay.
Right, and the amendment would change that to add the word reasonably in front of discovers.
So it would be 10 years after he reasonably discovers?
Correct.
You mean 10 years after he reasonably could be expected to discover? What do you mean? I don't know what reasonably discovers means.
I think reasonably discovers and reasonably could be expected to discover would be considered the same language.
Okay, I thank the chairman.
Mr. Chairman,
First, the gentlewoman from Texas seek recognition.
I'd like to strike the last word.
Gentlewoman is recognized.
Mr. Chairman, I rise to support H.R. 973, the Protecting Young Victims from Sexual Abuse Act, and I do want to thank Congresswomen Lois Frankel and Congresswoman Susan Brooks for their leadership, and will ask them to add me to this legislation as it makes its way to the floor. All of us have, with great expectation and excitement, watched the Olympics, whether it's the Winter or Summer Olympics, cheering on our national heroes. And so I believe that this is a debt of gratitude in respecting the joy and the pride that they give to the American people. This legislation comes on the heels of the allegations of sexual abuse at the hands of coaches and other Olympic professionals over the past 20 years, and reports of negligence of USA Gymnastics to bring these allegations to light. H.R. 1973 will address this problem by requiring amateur athletic governing bodies to immediately bring reports of abuse to law enforcement, establishing policies and procedures for preventing, reporting, and addressing allegations of sexual abuse, developing mandatory training and oversight practices, and extending the civil statute of limitation for cases. It is substantially similar to legislation introduced by Senator Feinstein. So I take note of the fact, Mr. Chairman, and I know that we in the Judiciary Committee have often made these legislative initiatives fit more aptly to be able to serve those that we're trying to protect. I just want to make sure that, as was asked by my colleague, Mr. Nadler, that we are not denying or shortening the opportunity for a reasonable or a individual to be protected with the terminology reasonably discovered. So I would like to, in a moment, Mr. Chairman, yield to you for your interpretation of that. But before I do that, let me also indicate that all of the members of this Congress and the American people have gone through some very difficult days. I think as I've reflected, I've recognized that this is not Republicans and Democrats. This is really the American people. We've gone through the firing of a FBI director. We've gone to the frightening revelation of classified information being detailed to a known spy, the ambassador to the United States from Russia. We've gone through the allegations made during a Coast Guard graduation of being treated as the worst treatment that any elected official has ever received. And I know that we are in very difficult times. I note that my colleagues in the Oversight Committee are still seeking to have a number of officials appear before them. Again, Mr. Chairman, because we must do this as Americans, I am asking, as my ranking member has done, several things. One, we asked for memoranda and documents at the early part of the year from the Department of Justice, which have never, as I understand it, at least I have not been given notice to review them. Those documents have never come. Secondarily, I believe it is appropriate that we have before us former Director of the FBI, Comey, and former Deputy Attorney General and Acting Attorney General, Sally Yates. Yes, a very fine and capable and well-respected individual has been appointed as a special counsel. Special counsel is under the Department of Justice and can be terminated at any time. And so I wish Director Mueller well. I've worked with him. I've had the privilege sitting on this committee, of which I admire and respect, for a number of years, and so I have known him during his entire tenure as the FBI director. That does not relieve us of our responsibilities on behalf of the American people. As other committees in the House have responded to their jurisdictional responsibilities, I would like us to respond to our constitutional and jurisdictional responsibilities. And Mr. Chairman, I say this as an American, as a senior member on this committee, as someone who's watched my ranking member work very hard to be collaborative, who have asked for the memos and memorandum, and who believes that the American people need to see an orderly questioning of the facts that have happened while the prosecutor continues his work.
Would the gentlelady yield?
I'd be happy to yield to the gentleman.
Thank you. I just wanted to rise to support what was just said. And I was pleased to see that former FBI Director Mueller has been appointed special counsel, but that does not relieve us of our obligation to investigate these matters ourselves, particularly issues that fall squarely within the jurisdiction of this committee. Democrats on this committee have sent numerous letters to the chairman calling for hearings to which we have received no reply. We have filed resolutions of inquiry which were rejected by party line votes. The House and Senate Intelligence Committees and the Senate Judiciary Committee have all found time to look into allegations concerning Russian influence over the 2016 elections. But we have not, and we have an even broader and a unique position as stewards of the Constitution. It is our duty that the President to see that the President stays within constitutional boundaries, but we have refused to examine a wide range of activities that raise serious constitutional concerns. Whether it is the President's ongoing conflicts of interest and possible violations of the Emoluments Clause, the troubling ties to Russia, or these new allegations of obstruction of justice, this is the committee charged with determining whether there is adherence to the Constitution, and we should pursue an investigation and certainly hearings into all of these issues, no matter where they may ultimately lead. The near daily revelations coming out of this White House demand action now. It is good to see that there is a special prosecutor, but as we know, the jurisdiction and the provenance of a special prosecutor is to investigate possible crimes, and maybe there were crimes committed, maybe not. That'll be for him to determine and process afterwards, perhaps. But the American people need a generalized investigation as to what is going on, as to whether there is improper influence in the FBI, improper influence by a foreign power, as to whether the FBI and the Department of Justice were compromised. In particular, those latter two are the jurisdiction of this committee. Now, we know that there are investigations going on within the House and Senate Intelligence Committees, but their jurisdiction is somewhat different. The Senate Judiciary Committee is having investigations. The House Judiciary Committee has a duty to do the same, and I urge that the chairman consider this and that we exercise the jurisdiction of this committee to look into what we should look into. We cannot expect, it is not his job to give a report, for the special prosecutor to give a report on what was going on to the American people, although he must give a report to the Department of Justice, but that report may very well be secret. We need a report such as was given in 1973 and again in 1997. We need, and on several other occasions, we need a report within the jurisdiction of this committee, and we need this committee to hold hearings, to call Director Comey and various other people, and to do what we have to do. It seems a little, we're examining bills here, some worthy, some not, depending on one's opinions, but it seems like we're fiddling while Rome burns, because these bills, some of them are very important, but there is an overarching issue before us to which we must react and do our duty. I thank the gentlelady for yielding, and I yield back.
Would the gentlelady yield to
I'd be
me?
happy to yield to the gentleman as
The time of the gentleman has expired. For purpose of the gentleman from Georgia seek
well, the
recognition.
ranking. Okay.
Could I be recognized?
Mr. Chairman, I move to strike the last word.
The gentleman is recognized, and he can then yield to the gentleman from Michigan.
Thank you, Mr. Chairman. I rise to speak in support of H.R. 1973. I want to yield to the gentleman from Michigan.
Thank you very much, my friend from Georgia. I wanted to associate myself with the gentlelady from Texas' previous remarks, and also the gentleman from New York, Mr. Nadler, have made a very reasonable interpretation of what our responsibilities are, and I think that they should be expanded as they suggest, not seeking publicity or raising emotions in any way, but in doing a thorough and accurate and appropriate examination of this issue before us. And I just wanted to thank both of them for it, and I thank the gentleman for yielding.
All right. I thank the gentleman. I would yield now to the gentlelady from Texas.
I thank the gentleman as well, and I want to build on, yes, we're building on each other, Ranking Member John Conyers and the Mr. Nadler of New York, and I'd really like the chairman to respond whether or not we can have a meeting, but we need to establish something, Mr. Chairman, that you have been a champion of, and that is the jurisdictional credibility and standing of the Judiciary Committee. As Mr. Nadler said, we are the holder and the protector of the Constitution, and frankly, the American people, without party identification, are seeking answers. The special counsel that it is now called, different from the independent counsel, is a fixture and a product of the Department of Justice. We thank the Deputy Attorney General for appointing Mr. Mueller, but their guidelines will be completely different, and I think there's a singular point. They can provide a report, they cannot provide a report. This is not a time for cover-up or darkness. It is a time for sunlight and transparency. No suggestion that this committee is trying to cover up, but if we don't do this together, if If we don't stand up and acknowledge that America is more important than we are, the integrity of the government is more important than we are, then I can assure you this will not set a good standard when we have other jurisdictional fights, when we have not taken our rightful place in these hearings and begin to be able to address them. I will conclude my remarks, and thank the gentleman for yielding, but I'll conclude my remarks by simply saying at some point, Mr. Chairman, you'll respond to the 1973 question that I had on this legislation that I support and want to co-sponsor, and thank Lois Frankel and Susan Brooks. But I do believe that we have a constitutional question and a potential constitutional crisis, and we need to be part of the uncovering and the discussion and the hearing for our members on what the next steps are, how we can prevent, that's our job, what has happened over the last 5 months in the United States through the Oval Office. With that, I yield back to the gentleman.
Would the gentleman from Georgia yield so that I can respond to the gentleman from Texas?
I would yield to the.
I thank the gentleman for yielding. First of all, tomorrow there will be a briefing of the entire membership of the House by the Deputy Attorney General of the United States on the matter related to the firing of FBI Director Comey. Secondly, as has been the custom of this committee in the past, we should allow the Department of Justice and the FBI to do their work. And that is why I join you in being pleased that the department has appointed a special counsel to look into the matters that you have described. But it would be inappropriate, in my opinion, for this committee to, at the same time, conduct a public investigation or fishing expedition into what you think may or may not have happened. We did not do that during the last Congress when there were serious allegations of criminal violations by the Democratic candidate for President of the United States. We waited until after the department had completed their investigation and held a hearing at that time. That may or may not be appropriate when the department completes its investigation into the matter that you are concerned about. I respect your concern, believe it should be investigated, but I do not believe that it is the appropriate role of this committee to do other than conduct oversight of the Department of Justice to be assured that they are doing their job. And we are doing that both in terms of the briefing tomorrow and in terms of both Republicans and Democrats approving of the appointment of the special counsel to make sure that that investigation carries forward in a responsible way.
The gentleman yield?
Mr. Chairman?
I think it's the gentleman from Georgia's time, which has
Would the
expired,
gentleman-
so I'll just go to the gentlewoman from California. For what purpose do you seek recognition?
Mr. Chairman, I wanted to talk just briefly about the bill that we're marking up.
Gentleman's
and then,
recognized for 5 minutes.
strike the last word. I want to say how important I think it is to adopt this bill. I have had the obligation and responsibility to meet with individuals in my own district who have been abused as swimmers, and we do not have adequate law to deal with their situation. So I think this is an important step, but only a first step. We will get more information because of the provisions in this bill, and we may need to do more things. Having said that, I want to address the other issue that has been mentioned by the ranking member, my colleague, Ms. Jackson, and others. I think all of us, and I've yet to hear a member who isn't actually relieved that the Department of Justice has appointed Mr. Mueller, who we all respect, to do an investigation. You're exactly right. It is not our job to interfere in that investigation. And we will see what the results are when the investigation is complete. However, that investigation is unrelated to our obligation in some ways. His obligation is to find out whether there is reasonable cause to believe that a crime has been committed. Could have been by staffers or other people, who knows? He may find out that there is nothing that leads him to that belief. We'll find out. But it is possible to damage our Constitution without committing a crime. And in fact, that has happened in the past. I think back to the role this committee played in 1974 to uncover actions that posed a threat to the constitutional system of government. I'm not suggesting we are at that point today. However, I do think aggressively receiving information that Mr. Nadler referred to is an important responsibility that we have. I'm mindful that our counterparts in the Senate are stepping forward to accept their responsibility to gather facts. And that's all we're saying at this point. We are in a fact-gathering mode, and I'm hopeful that we could work together to make sure that that responsibility is discharged. So I didn't want to stray too far from H.R. 1973, which I think is an important first step. And by the way, it is important to note it does not preempt state law that protects individuals from abuse. But I did want to agree with my colleagues that we should work together to obtain this information that we have asked for on a bipartisan basis in some cases and others not, just so we can discharge our obligation in fact-finding. And I see that Mr. Nadler would like me to yield, so I'm happy to yield to my colleague from
Thank the gentlelady for yielding. I think the gentlelady is exactly right on this point. The special prosecutor's job is to investigate possible crimes. But there can be manifest damage done to the Republic or to the Constitution by actions that are improper but are not crimes, or are not crimes that can be proven. So that is why, in addition to a special prosecutor, we need ultimately an independent commission, but at least examination by the relevant committees. And ours is one of the relevant committees. We have an intelligence committee investigation, fine, because some of this impacts the intelligence function. But the functioning of the FBI, the functioning of the Department of Justice, many of the actions of the White House arguably involve the Constitution and the law, and certainly that's our jurisdiction, and completely separate from a criminal investigation and not interfering with the criminal investigation. We should look into these matters in terms of damage to the Constitution, adherence to norms. You know, you can damage the Constitution and constitutional practices by violating norms which have always been adhered to or which are taken for granted, and maybe we ought to make some of these norms laws. But these are the areas that this committee ought to be investigating, and the fact that there's a special prosecutor does not absolve us of our responsibility, and to wait until the special prosecutor finishes, which could be several years for all we know, would be a real abdication of our responsibility and a disservice to the Republic. I thank the gentlelady for yielding. And
thank you, and I see my time has expired, Mr. Chairman, so I yield back.
For purpose, the gentleman from Tennessee seek recognition.
Strike the last word.
Gentleman is recognized for 5 minutes.
I've listened to much of the discussion, Mr. Chair, from members on this side of the aisle about the controversies, and I don't know that anybody's brought up a fact that I think is relevant. That's the fact that the FBI is under our jurisdiction for review, and that the firing of an FBI director, Mr. Comey, is something that this committee should be the first committee to look into. And to have Mr. Comey here to tell us what happened, and if we can get to the bottom of why he was fired. The FBI director gets a 10-year term for specific reasons so that he's beyond partisan politics and goes over and beyond even two-term presidents. And there are certain standards by which that person can be fired, and they are not that you're firing a person because they weren't your lackey or didn't pledge allegiance to you or fealty. And those are things that I think are relevant and we should look into. And I'd like to ask the chair if he wouldn't consider asking Mr. Comey to come to this committee and looking into the issues surrounding the firing of the director of the FBI.
The gentleman would yield.
Yes, sir.
The fact of the matter is that is the purpose of the special counsel has been appointed, and I think it would be inappropriate for this committee to interfere with that investigation. We are going to get a classified briefing tomorrow from the Deputy Attorney General on that matter that has already been scheduled prior to the time of the appointment of the special counsel. We'll proceed with that and see what is revealed by that. I trust you'll be in attendance tomorrow.
I will be in attendance, Mr. Chair. I would suggest that it's my understanding that the charge given to Mr. Mueller was to investigate leaks or work that the Russians or Russian government or Russian individuals might have been in collusion with Trump or the Trump campaign. And there is a catch-all where they could go to associated activities. Nothing in the charge directly goes to the firing of the FBI director. And while the president did on his second statement on why he fired him, he said he fired him because of Russia. The first statement was he fired him because he was coming to the defense of Secretary Clinton and the way she was treated by Mr. Comey. But even if he fired him because of the second reason, which is the one that seems to be the best rule, that he fired him because of Russia and the Russia investigation, that does not mean that the special prosecutor's charge is to look into that firing. He's supposed to look into collusion between the Russians and Trump. And so I still think it's relevant that we have this, and I don't know that Mr. Rosenstein will testify to that while he did give the first explanation, which was then put into the heap of garbage in the White House, saying it wasn't relevant, that's not why they fired him. Mr. Rosenstein wouldn't know what Mr. Comey's interactions were with the president, if the president pressured him, if the president asked him to give him his total loyalty and fealty, and if the president asked him to back off. So I still think it's relevant that it come to this committee.
The gentleman yield.
Yes, sir.
The widely held view of those who have read the appointment of Mr. Mueller is that he has very broad jurisdiction to look into matters related to the underlying investigation that was already proceeding in the Department of Justice.
Let me ask the chair another question, just curious. I ventured over into your side of the committee room, the ante room, which I remember fondly when Mr. Conyers was chair, that we had large masses of food there, and we had lots of room and TV, and it's a nice spread. We don't have that same spread now. We're kind of crampled. Occasionally you send us pizza, but we don't get much. But I've noticed 3 pictures on the wall that you chose, Mr. Chair, and I wish you'd edify the members on this side of the 3 pictures, the 3 presidents you chose, and why they're there.
Getting very far afield from the bill that is before this committee, which I think is very popular on both sides of the aisle, but those 3 presidents are former members of the Judiciary Committee, and that's why they're hanging on the wall there.
Is there a room for Mr. Pence?
Mr. Chairman, Mr. Chairman.
For what purpose the gentleman from Pennsylvania seek recognition?
Move to strike the last word.
Gentleman's
That'll be
recognized
very
for 5
brief.
minutes.
If my good friend is concerned about a snack, my wife makes a wonderful peanut butter chocolate fudge topping, and I will bring that snack in for you just out of showing the camaraderie from one side to the other.
Would the gentleman
For what
yield?
purpose the gentleman from New York seek recognition?
Move to strike the last word.
Gentleman is recognized for 5 minutes.
I just want to associate myself with the comments that have been made by the distinguished ranking member and all of the other members on our side of the aisle who have raised this question of jurisdictional integrity. It was my understanding, I've served on this great committee during the entire time that I've been here in the Congress, that we are the custodians of the United States Constitution, this committee, that we have jurisdiction over the Department of Justice, this committee, that we have jurisdiction over the FBI, this committee. We have jurisdiction over the criminal code, obstruction of justice, abuse of power, this committee. We have jurisdiction over the extraordinary remedy that some Americans are contemplating, this committee. Now, from the very beginning of this Congress, Democrats have raised the question of jurisdictional integrity, urging the chairman to pursue the widest possible degree of oversight, not as part of a witch hunt, but it's part of our own jurisdictional integrity, Democrats and Republicans. And every time we've raised the question, 17 different intelligence agencies concluded that the Russians interfered with the election to hurt Donald Trump, we were mocked. Communications taking place between Donald Trump's campaign and the Russians at the same time, they were hacking into our election. People like Carter Page and Manafort and Roger Stone and Jeff Sessions and Michael Flynn, Jared Kushner, we were mocked. Michael Flynn committed a crime in December of 2016, it appears, when he had a conversation with the Russian ambassador and then lied to the vice president about it. We raised that, we were mocked. Taxes haven't been disclosed by the American people, we were mocked. This is just a witch hunt, a fishing expedition, nothing there, Democrats. And then Sally Yates is fired, the acting attorney general, shortly after revealing to the White House her belief that Michael Flynn could be a Russian asset. We raised that, we're mocked. The United States Attorney General for the Southern District of New York, Preet Bharara, is fired after Donald Trump promised this U.S. attorney that he would stay on shortly after it was publicly revealed that Bharara's office was investigating one of Trump's cabinet secretaries and close allies at Fox News. We raised that question, we're mocked. James Comey, the FBI director, acknowledges publicly for the American people that there's a criminal investigation. I think we've got jurisdiction over the criminal code here on the Judiciary Committee. Criminal investigation of the Trump campaign and possible collusions with the Russians. We're mocked. We're just interested in a fishing expedition. Donald Trump fires the FBI director and acknowledges that he was concerned, upset about this so-called fake Russian collusion issue. We raised that issue, we're mocked. It's all apparently a fishing expedition. It appears that Donald Trump may have attempted to obstruct justice as it relates to his conversation with James Comey on February 14th, suggesting that the FBI not vigorously pursue its investigation of Michael Flynn. Again, we're mocked. And now everyone's singing Kumbaya because a special prosecutor was appointed. That's actually fake news. That's not the reality. There was no effort in a bipartisan fashion for us to say, let's just get to the bottom of what occurred. And so all we're saying right now, whether you think something happened or not, notwithstanding the litany, the mountain of evidence that has emerged that something wrong may have occurred, even if you can't come to that conclusion, even if some folks want to bury their head in the sand for whatever the reason, at least respect the jurisdictional integrity of the Judiciary Committee and not let it be hijacked by other committees in the House or allow the Senate Judiciary Committee to proceed as if there's only one House in the United States Congress. I yield back.
For purposes, the gentleman from California seek recognition.
Move to strike the last word.
Gentleman is recognized for 5 minutes.
I'd like to talk about two issues. The first is the bill before us today, H.R. 1973, the Protecting Young Victims from Sexual Abuse Act of 2017. This is a good bill. It's an important bill. I fully support it. And I want to thank Attorney John Manley for his hard work on this issue, as well as so many others for their work on this legislation. And then second, I'd like to align myself with my colleagues discussing the need for an oversight hearing. The mission of this committee is to conduct oversight into the Department of Justice. And there has certainly been a lot of chaos in that department, from the firing of FBI director, to the firing of Sally Yates, to the firing of Preet Bharara. We need to have a hearing so the American public can get the answers they need to know what happened. I understand that the chairman disagrees, but it seems to me that there is an issue where all of us, Republican and Democrat, can agree on this, which is we need to make sure the Department of Justice has the resources necessary to conduct the investigations they need to do. There have been reports that FBI Director Comey was unable to get the resources he needed to go forward in a good way with FBI investigation. Now that we have a special counsel, I think we need to have a hearing to make sure that the FBI as well as the special counsel have the resources they need, the agents and the prosecutors, to conduct the fair and impartial investigation in a speedy way, which is what the White House also wants to do, an expedited way for the American people to see what happened. And when I'm done, would love for the chairman to address that issue, and I'm going to yield the balance of my time to Representative Nadler.
Thank the gentleman for yielding. I just want to point out that the chair has said, obviously, that it would be inappropriate to hold hearings on these matters while the special prosecutor is functioning. But House committees have hosted a wide range of hearings on sensitive matters that were then under criminal investigations. For example, the 1993 hearings on the Waco tragedy, the Whitewater hearings, the 1987 Iran-Contra joint hearings, not to mention the Benghazi investigation. Under your leadership, we have also held hearings that touched upon the shootings in Orlando, Florida, and San Bernardino, California, the attacks on the U.S. consulate in Benghazi, the surreptitious recording of conversations with employees of Planned Parenthood, allegations of misconduct in certain federal law enforcement agencies, and the Boston Marathon bombing. In each of these cases, the related investigations by the relevant agency were still ongoing, and we pressed ahead with oversight hearings anyway. So there is certainly ample precedent for the committee, for this committee and other committees, holding hearings on the public aspects, on the congressional on the public aspects of these matters while criminal investigations were going on. And again, a criminal investigation looks only at that, at whether crimes were committed. Our purview is well beyond that. We're not, well, we may be interested, but we're not primarily interested in whether crimes were committed. We're primarily interested in protecting the Constitution and protecting the public welfare. And that is our job, and it would be a dereliction of duty, in my opinion, to say, no, we should wait years until the special prosecutor issues his report, which may very well be years. Other special prosecutors have taken great lengths of time. We don't know. And as I said, other committees the intelligence committees in both houses are investigating this. The Senate Judiciary Committee is investigating. They have more or less the same jurisdiction that we do, and it would be a public disservice to use the fact or the excuse that that there is a criminal investigation going on to avoid a public hearings and investigation of the public matters that are of such great public concern. I thank the gentleman. I yield back to him. Mr. Liu. I thank him for yielding, and I yield back.
I yield back.
What purpose does the gentleman from California seek recognition?
Move to strike the last word.
The gentleman is recognized for 5 minutes.
Chairman, I look forward to getting to the markup shortly, but I would like to weigh in a appropriate, I hope, way to this dialogue. Mr. Jeffries used the word evidence many, many times, and he's an attorney of training and experience. I've got to tell you, I think what we are making a mistake about as we look at the special prosecutor and his work is he will be seeking evidence. We have been following news stories. We hear in a news story that something has occurred. We later find out that the verbatims or the specifics are different. And in some cases, there's revisions that go on for a period of time. But at the end of it all, we are following news stories. We're not yet following the evidence. Director Mueller is going to have the obligation to follow the evidence. I might suggest that this committee's jurisdiction is appropriate to oversee his work, and I urge the chairman and ranking member to assert that jurisdiction in this case, as I would at all times. But let me go through a few things that I heard some of my Democratic colleagues say that I think is noteworthy and that we should, in fact, include in a dialogue sooner, not later. Does the special prosecutor, does Director Mueller, does he, in fact, have the assets he needs, that he believes he needs? Does he, in fact, have the independence that is required which we could get into assets and independence, like separate facilities, separate email, the ability to have people that work only for him and are not reportable to others, a whole litany of things that this committee knows the rules and how they work. What does the director believe the breadth of his investigation is? We've had some dialogue here today about what is or isn't. My experience in looking at special prosecutors and working with the Department of Justice is they often expand when they see something, or they come back to a committee or to the appointer and ask for expansions when they think it's appropriate. And I would suspect that the former FBI director is quite good at doing that, from my experience. Lastly, I believe the timeline that he expects to at least be prepared to report in some meaningful way to committees what he believes is there in the way of evidence, perhaps not evidence of criminal wrongdoing, but evidence sufficient to know whether or not our election was interfered with, and for several committees, the ability to know what is the plan to prevent it from happening in the future if, in fact, techniques were used that could be used again. So I'm going to conclude, Mr. Chairman and Ranking Member, by saying I know that we will not end dialogue just because I spoke today, and I know there will be calls for commissions and other investigations. But I would urge the chairman and ranking member, as the senior and, if you will, the adults here in the room at all times, and I commend you both for being that you should look at an appropriate way of corresponding to ask these questions, whether it's an in-camera review, a meeting with the director, or anything that would be appropriate in your decision after consultation, to make sure that Mr. Mueller has the assets, the independence, an understandable breadth of the initial investigation, and a timeline that he anticipates based on his decades of experience. And I would hope all of us, at some point in the hours and days to come, would realize that that's the next step. It's not for us to talk about what we do. It's probably for us to make sure that the assets, the independence, and the breadth of mission is available. And I leave you with that, Mr. Chairman, and I thank you.
Would the gentleman yield?
Of course I would yield.
Chair appreciates the gentleman's thoughts and will take his recommendations under advisement.
Thank you. I yield back.
What purpose does the gentleman from Maryland seek recognition?
I move to strike the last word, Mr. Chairman.
Gentleman's recognized for 5 minutes.
Thank you very much. I wanted to add a few thoughts to the situation, and I want to begin by associating myself with the remarks of Mr. Hakim, because what we have been asking for from the very first meeting, I think, has been precisely evidence and facts. That has been our demand from the beginning. We have sought a comprehensive 9/11 style investigation into the Russian connection, into Page and Stone and Manafort and Flynn and Jared Kushner and the whole staph infection which seems to have overtaken the Trump White House with respect to Russia. We've been asking for that. We've been asking for a hearing on it. So now we indeed have a special counsel that has been named by the Department of Justice, and this is progress indeed. But I want to also associate myself with the remarks of Mr. Liu, because our committee has specific jurisdictional responsibility to make sure that this investigation within the Department of Justice is undertaken with efficiency and with institutional respect for the special counsel's own discretionary authority. So I also think that we need to have a hearing to make sure that the newly appointed special counsel, Mr. Mueller, a distinguished former FBI director who is someone very well up to the task, is given sufficient resources and is given sufficient independence within his office. As everybody knows, the independent counsel statute that was adopted after the Watergate investigation has lapsed, and it came under fire both from Democrats and Republicans. There were various investigations, the Iran-Contra investigation on one side, the Kenneth Starr investigation into the Clintons on the other side, which attracted a lot of fire. And the independent counsel statute went down. So we're depending on the provisions within the Department of Justice's own rules for the establishment of this special counsel, but we need to make sure that that special counsel really has the authority to do the job, and we think, at least I think, that the right person has been chosen given these circumstances, but we want to make sure that the Attorney General's recusal is in fact implemented, and that his recusal is something that is respected within the Department of Justice, and the special counsel gets to pay attention to the very serious crimes and misdeeds which go to the very question of constitutional democracy in America. We know from our own intelligence agencies that American democracy came under attack in 2016. There was a concerted effort by Vladimir Putin and his paid agents to commit cyber espionage and sabotage of America's democratic institutions, including the Democratic National Committee, the Democratic Congressional Campaign Committee, and lots of other political entities in the country. And we've seen a repetition of that, most recently in the Netherlands and in France, by the Russians. So we need to get to the bottom of this massive attack on American democratic sovereignty, and we need to determine whether or not there has been collusion by political forces within the United States, specifically within the Trump campaign and around the Trump campaign, to enable this attack on American political democracy. What we are looking for is precisely the facts and the evidence, and that has been our sole object from the very beginning of our discussion of this in this committee. So we are delighted that now the special counsel, which was resisted by so many, is being hailed by everyone as the right move. But that should be just the beginning. And with that, I will yield the remainder of my time to Mr. Cohen.
Thank you, sir. I appreciate it. The question, Mr. Issa made a point about the special prosecutor, but you know, the special prosecutor is looking at criminal violations and bringing criminal charges if they are merited. This committee's responsibility is policy, and we should not stop our purpose of seeing that we have the right laws based on the right policy for our country. That includes the term and the appointment of the FBI director. Maybe the FBI director should be like a judge and be given a 10-year term and not be subject to firing. Maybe it needs to be tightened up on the basis of which he or she could be fired. Maybe the term needs to be longer or lesser, but those policy decisions are still here, and I think we should have hearings on the appointment of and the firing of the FBI director and any need for change and what occurred. And I yield back the balance.
Mr. Chairman.
For what purpose does the gentleman from Washington seek recognition?
Move to strike the last
The gentleman
word.
is recognized for 5 minutes.
Thank you, Mr. Chairman. I first want to rise in strong support of the bill under consideration, H.R. 1973. This is an incredibly important bill for sexual abuse victims across the country, and I want to thank the advocates that are in the room and those who have worked to put this before us in a bipartisan way. Mr. Chairman, I also want to associate myself with the comments of many of my colleagues who have spoken before me, and I want to respectfully submit that I'm not sure when this committee would find it appropriate to have hearings into any of the issues that have been mentioned today. We are almost 5 months into this administration, and as Mr. Nadler said, I believe that this committee it really is a dereliction of duty that this committee is ceding authority over any of these extremely important issues to the American people that are before us. With all due respect, saying that we are pursuing things just based on news stories doesn't make any sense. We're talking about issues where 17 intelligence agencies weighed in on the question. We're talking about issues where an FBI director has a memo that says that he was asked to not pursue an investigation into Michael Flynn. And just now, Michael Flynn actually said that he will not honor the Senate Intelligence Committee's subpoena. So what moment would it be appropriate, Mr. Chairman, for us in the Judiciary Committee to call before us those people who can provide us with facts. We would love to have facts. That is actually what all the members on our side of this committee have been calling for many months now. If we could actually look at those facts and determine where those facts lead us, I think that would be within the purview of the Judiciary Committee of the House. I don't know why we're ceding that authority continuously in the name of these issues being spurious. The reality is the American people across the country called for and expressed outrage over and over again, which is why we finally have a special prosecutor. But that is just one piece of what we're looking at. That involves criminal acts, but there is much that is at stake within our democracy that does not have to do just with criminal acts. And I think this committee in particular should be looking at and trying to get to the bottom of where we are at this moment in history. And the reality is, Mr. Chairman, that history smiles brightly on those who speak out, even at the cost, perhaps, of what others in the party might be saying. This is a moment for us to put country before party, and I think, and I hope that we will be allowed on this committee to weigh in on these issues of critical national importance. I would like to yield now to my colleague from Texas, Representative Sheila Jackson Lee.
I want to thank the gentlelady for her courtesies, and I want to thank my colleagues for their very important dialogue, and I want to capture some of the comments that have been made. But as I do that, let me also say that I enthusiastically support the underlying bill, H.R. 1973. But let me remind my colleagues that there is a responsibility of this committee. And, Mr. Chairman, to be honest, this is not a burden that should be suffered only by yourself. There are distinguished lawyers in this room, Republicans and Democrats. There are non-lawyers in this room. And so the members of the committee, Republicans and Democrats, have an equal responsibility. And I hope my colleagues who are Republicans, who are scholars, former prosecutors as well, they really hear the truth of what we're saying. And the truth of what we're saying is that we cannot abdicate and be derelict in the responsibilities of showing the American people that the Constitution is rules. That rules. And so when you find that Flynn has spoken, and other operatives have spoken to Russians 18 times in the last 7 months of the campaign, that is soiling the election and soiling the presidency. And when you find out that Flynn was sitting in a meeting advising against an operation or collaboration with others because he was being paid by Turkey and they didn't want that operation, that is soiling the presidency. And it is crucial that not only do we deal with the questions of how we stop this from happening again, that's what the Judiciary Committee's responsibility is. And I ask my colleagues, Republicans, you can't yield that responsibility, nor can you yield the responsibility that the American people look to this committee, rightly so, over the years, to be the arbiter of truth and the arbiter of the Constitution. And we cannot reject that there's been an abuse of power and there has been a doubting or damaging of the public trust.
Time of the gentleman has expired.
I would offer to say I thank the gentlelady that we, Mr. Chairman, in spite of all the arguments, we must do our job, and it is not being done. I yield back.
What purpose the gentleman from Florida seek recognition?
Move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman, and I wanted to take just a moment to respond to the accusation that the Judiciary Committee is somehow ceding our authority. We are the Judiciary Committee. We are not the HR department at the Department of Justice. We're also not FBI investigators. Our job is to make sure that investigators have the resources and authority to accomplish their work. Democrats on this committee and throughout the Congress have called for a special and independent counsel. That has now occurred. And it would seem to me to be premature to call in Director Mueller, disrupt the beginning of his investigation as he plans out the days and weeks to come. There will be a time, surely, where this committee will accept reports, whether in open hearing or in camera, on the work that is going on at the Department of Justice, and we will make sure that that investigation is unhindered and well-resourced. But rather than living in the melodrama of news stories and rumors and anonymous reports, let's allow Director Mueller to do his work. let's ensure that we remain consistent with our oversight plan. I think it's noteworthy that when the Judiciary Committee first came together, we had an oversight plan. We had a document that laid out our intent to ensure that if there was meddling in the election, if there were inappropriate acts, that we would follow up on those things. And so as Director Mueller does his work, let's do our work. Before us now is legislation that would allow the Judiciary Committee and the Congress to speak with a unified voice against horrific acts of sexual violence, human trafficking, and the devastating consequences of illegal immigration. And so I'm hopeful, Mr. Chairman, that we will exercise our oversight function appropriately, consistent with the oversight plan and the work plan that the chairman laid out at our very first gathering, and that we'll continue to work on the things that can actually improve quality of life for Americans by stopping sexual violence, by ensuring that we've got the systems in place for reporting and consequences for those who would take advantage of young people, and I look forward to that work commencing. I yield
Gentleman
back.
yield?
Sure.
I had a question. The FBI was conducting a criminal investigation into the possibility of collusion between the Trump campaign and Russia. Is that right? Is that a fact, or is that speculation?
Well, Mr. Jeffries, it's been well documented that there is an ongoing investigation of Russian activity relative to the election.
And
the Judiciary Committee, in fact, acknowledged that in our oversight plan.
And James Comey was leading that investigation, true?
Yeah.
And Donald Trump made the decision to fire the person who was leading the investigation into possible illegal collusion between his campaign and Russia. Is that right?
Well, Mr. Jeffries, you impute upon the president that motive, which has not been established.
No.
That's the very reason.
I didn't say anything about motive.
No, but the premise of your question to me was that somehow this was driven by a desire to be disruptive to an investigation when there is, in fact, no evidence that that's true.
Not at all.
Now my belief is that we should, in fact, allow that investigation to persist. We should allow Director Mueller to do his work. You have called, both in this committee and on the floor of the House, for a special and independent review. You've gotten your way in that respect. And so why would we now want to go and sort of inject more politics, have less independence? My belief is that we ought to allow that investigation to persist. There will, of course, be a time where the Judiciary Committee has an obligation to ensure that that investigation is independent and well-resourced and consistent with our oversight plan that we've adopted in a bipartisan fashion. I'm entirely confident that we will do that without ceding any jurisdiction of the committee.
Did Trump make the decision to fire the FBI director, yes or no?
Yes.
And is that an HR issue, as you've suggested, to fire the head of the FBI who was leading a criminal investigation into possible collusion of the Trump campaign? Or is that possibly something more that falls within the jurisdiction of this committee, like obstruction of justice, abuse of power, or something worse? That, to me, I'm just getting clarification. Is your position that that's an HR issue that we should dismiss?
Mr. Jeffries, my position is that we should allow that investigation to persist without injecting more partisan politics and without sort of feeding the fervor around that review. Why not just allow the activity to persist, which you have called for, which is an uninterrupted, uninfluenced, independent investigation? That's what's ongoing, and what's a little bizarre for me is that now Democrats on the committee are calling for us to further inject ourselves as a Congress when weeks ago you were calling for more independence. So let's allow that independence to
I do
go
thank you
forward.
for yielding. I would just suggest it's not an HR issue, it's a possible constitutional crisis, which is squarely within our jurisdiction. Thank you.
Are there any amendments to H.R. 1973? What purpose does the gentleman from Louisiana seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized for 5 minutes.
Mr. Chairman, I would concur with all of what I've heard from my colleagues today, raising grave concerns, and just would, again, I can engage in party politics probably with the best of them, and I'm sure that anyone on your side can, but at some point, we have to put patriotism over party, and I would just say that this is one of those times where our democracy is so fragile and has been attacked by a foreign country, and we need to know how, when, where, and the entire extent. And with that, Mr. Chairman, I would yield the time to my colleague from Georgia, Mr. Johnson.
I thank the gentleman for yielding. Mr. Chairman, as I said, I rise in support of H.R. 1973. It's an important piece of legislation. I look forward to this committee passing it out of this committee on to the full House. And we have a lot of work, such as these kinds of measures, to do as a judiciary committee. But, Mr. Chairman, we are facing a time of great challenge now. The nation is challenged. The people are watching. The people smell and see and hear a cover-up unfolding. They see an abuse of executive power. They are troubled by the perhaps treasonous activity of Russians in the Oval Office the day after the firing of the FBI director. They're hearing that this Oval Office meeting with top Russian spies was requested by Putin himself. They are wondering, what is the connection between Putin and our president? Because the president has a pattern and practice of yielding to Putin, and it's almost as if Putin has a special hold on our president. And so the people are looking at this. They understand that the FBI director is on top of a counterterrorism and criminal investigation about possible collusion between the Trump campaign and the Russians, after 17 intelligence agencies have concluded that there was an attempt by Russia to influence the most recent presidential election. So this is something that the American people know. They've been following this, and they are getting more and more suspicious of a cover-up. And so citizens of the 4th Congressional District in Georgia have been bombarding my phone lines with requests that I, as a member of the Judiciary Committee of the House of Representatives, take action to help the public become more confident that Congress is exercising its responsibilities to provide oversight. And what they want, Mr. Chairman, are hearings, because they realize that the special counsel appointed yesterday is a criminal investigation and a counterintelligence, a counterterrorism investigation that may or may not yield a final report, and that may take years to get to the bottom of the investigation. The public is demanding that Congress take action now to assure them that we're doing our job, providing oversight. And it's this committee's responsibility to provide oversight over the Department of Justice. We've seen abuse of presidential power that is directed towards that very Department of Justice, that is eroding justice. And so I would implore this committee to take this matter up and to hold hearings to investigate how abuse of power erodes public confidence in our Department of Justice, how we can bolster the American people into knowing that our republic is still safe. Treason will not trump patriotism. And with that, I will yield back.
I would yield back, Mr. Chairman.
Are there any amendments
Mr.
to the
Chairman?
manager's amendment to H.R. 1973? For what purpose the gentleman from Rhode Island seek recognition?
Mr. Chairman, I move to strike the last word.
Is recognized for 5 minutes.
Thank you, Mr. Chairman. I offer my strong support to H.R. 1973 and look forward to its passage. But I feel compelled to join my colleagues this morning to highlight the dereliction of duties of this committee to not begin in a serious way to conduct oversight hearings in light of recent events. The Judiciary Committee has a special responsibility to uphold the rule of law and to provide oversight to the administration of justice in this country. We have seen in the last week reports of disclosure of classified information by the President of the United States in a meeting in the Oval Office, not covered by the American press because the American press was excluded from that. You heard that right. The American press was excluded from a meeting in the Oval Office between the President of the United States, the Russian Foreign Minister, and the Russian Ambassador, in which he shared classified information that's been reported that will undermine the national security interests of the United States. And on the heels of that, we heard shortly after that that the President of the United States fired the director of the FBI, admitted that he was thinking about his handling of the Russia investigation when he made that decision. And it would happen shortly after the person charged with conducting this investigation asked for additional resources to conduct this investigation. We also learned in the last week that there was it has been reported that there is a conversation between Director Comey and the President of the United States in which first the President asked the Vice President of the United States and the Director of the FBI to remain and ask the Vice President of the United States and the Attorney General to leave the meeting, to leave the Oval Office. One has to ask, why would you ask the Attorney General of the United States and the Vice President to leave the office? And then we learn, according to reports, that in that conversation, the President of the United States asked or suggested to Director Comey that he should just leave Michael Flynn alone, let this go. It's just been reported that Michael Flynn's lawyers have now acknowledged they will not honor a subpoena from the Senate Intelligence Committee, and that Mr. Flynn will refuse to come before the United States Senate. So there are a number of issues here that strike at the very heart of our democracy. And we have a responsibility. This should not be a partisan issue. We have a responsibility as the Judiciary Committee to conduct proper oversight, to help to do our part. There's now a special prosecutor, a special counsel, there are intelligence committees. We play a role as well. We shouldn't look to other committees to do our work. This is in our oversight plan. Some of my colleagues have referenced that. The oversight plan is not an excuse not to do our job. It, in fact, compels us to do our job. It's an agreement that we will do it. And so we have a responsibility to conduct serious hearings, to do our part to generate information so that we can really find the facts and see where they lead and hold the individuals accountable for their behavior. And what we have not had in this committee is a serious hearing to address these issues. It is our responsibility. The American people are watching this and they expect us to do our job. These raise very serious questions. And we have to be certain that we're getting to the facts. I don't think anyone should celebrate or be overly anxious to get to a place where we think grounds may exist for the removal of the president from office. That's a serious charge, and it will have very serious consequences for our country. But we have a responsibility to confront this moment in our history, so that we can look back and know with confidence we've done our job, that we've done what is necessary to fulfill our responsibilities as the members of the Judiciary Committee. And so I urge my colleagues on both sides of the aisle to understand that this is a moment where we need to put our country before a political party. And I ask my colleagues, particularly on the other side of the aisle, to join us in our call for hearings to be done in a responsible and serious way that will help us get to the bottom of this, to see where these facts ultimately lead, and to be sure that we are demonstrating that as members of this Judiciary Committee, that we understand that no one in America is above the law, and that we will honor our responsibilities as members of this committee to ensure that that principle is vindicated, and that we bring before this committee individuals to testify to help us find the truth and hold those accountable and protect the integrity of our democracy.
The gentleman yield.
And with that, I yield to Mr. Raskin.
Thank you, Mr. Cicilline. I just wanted to restate my very strong support for H.R. 1973, the Protecting Young Victims from Sexual Abuse Act of 2017, and I want to salute all of the advocates who've come to work on it. I yield back.
Gentleman yield. I'm right here.
Time of the gentleman has expired.
I had an inquiry.
All
Mr.
time
Chairman,
has expired.
on 1973 about the modification that you had. Is that going to weaken the ability for the victims to be able to receive?
The gentlewoman would
relief?
suspend.
I'd be happy to
I've already answered this question for the gentleman from New York, and we are happy to consider further amendments or to consider further discussions before this bill goes to the floor. But
Thank you, Mr.
we
Chairman.
think that the bill is in good condition the way it is written now, and I would now ask the members to vote on the manager's amendment. All those in favor respond by saying aye.
Aye.
Those opposed, no. Being the chair, the ayes have it, and the amendment is agreed to. A reporting quorum being present, the question is on the motion to report the bill H.R. 1973 as amended favorably to the House. Those in favor will say aye.
Aye.
Those opposed, no. The ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views, and without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 2473 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2473, to ensure compliance with the Justice for Victims of Trafficking Act of 2015, to make strides toward eradicating human trafficking and for other purposes.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. Human trafficking has permeated communities and neighborhoods across America. It is currently one of the most profitable crimes in the world after the drug trade, and its victims have endured horrific trauma, violence, and abuse. That is why it is particularly egregious that victims of trafficking across the United States continue to be overlooked and underserved. There is a tremendous need for domestically for improved victim services, trauma-informed support, better data on the prevalence and trends of human trafficking, and effective mechanisms to identify and rescue trafficking victims. H.R. 2473, the Putting Trafficking Victims First Act of 2017, introduced by Congresswoman Ann Wagner, is an important step toward addressing these critical needs. This legislation will help provide stakeholders from law enforcement to prosecutors to service providers to government officials with the guidance and information they need to better serve victims of trafficking. One important place to start is in the courtroom, where victims can benefit greatly from victim-centered approaches oriented toward victim recovery. The Trafficking Victims Protection Act provided mandatory restitution mechanisms for victims of trafficking, but there are still many obstacles in federal courtrooms that prevent victims from accessing this restitution. H.R. 2473 will thus direct the Attorney General to report on efforts to increase mandatory restitution, to improve victim-centered practices in criminal proceedings, and to understand how access to appropriate victim services can encourage victims to participate in the criminal process. In addition, H.R. 2473 will advance U.S. responsiveness to trafficking victims by improving data collection. The bill instructs the National Institute of Justice to develop robust, comprehensive methodologies to determine the prevalence and trends of human trafficking in the United States and evaluate the effectiveness of policies and procedures to identify victims and address their needs. Importantly, the Put Trafficking Victims First Act will direct the Attorney General to provide training and technical assistance to government agencies, prosecutors, and law enforcement on how to implement victim-centered approaches to investigating, prosecuting, and preventing human trafficking. The bill promotes evidence-based, trauma-informed care and physical and mental health services for victims and ensures that all victims have access to services. Moreover, the bill encourages law enforcement officers and prosecutors across the country to make every attempt to determine whether an individual's participation in trafficking is free from force, fraud, or coercion before arresting or prosecuting them. Lastly, the Put Trafficking Victims First Act of 2017 expresses the sense of Congress that states across the nation should implement trauma-informed, victim-centered care for trafficking victims. all victims of trafficking should be afforded the same justice, dignity, and respect that other victims of crime receive. The bill likewise encourages states to develop vacatur provisions that would ensure victims of trafficking aren't criminalized for offenses that were direct results of being trafficked. And I would like to thank Congresswoman Wagner, the sponsor of this important legislation, for her commitment and tireless efforts on behalf of trafficking victims. As we look forward to a day when the United States is no longer plagued by the horrific crime of human trafficking, I urge my colleagues to support this important legislation. And it's now my pleasure to recognize the ranking member of the committee, Mr. Conyers, for his opening statement.
Thank you, Mr. Chairman. Members of the committee, this measure, H.R. 2473, is intended to improve the implementation of the Justice for Victims of Trafficking Act of 2015. The 2015 Act expanded the federal response to trafficking concerning services and benefits for victims, criminal justice, domestic sex trafficking of children, and interagency coordination and training. I support this measure for several reasons. To begin with, this measure will strengthen the effectiveness of the 2015 Act in various ways. For example, H.R. 2473 requires that training be provided for prosecutions of traffickers and support for state services for trafficking victims. When children have fallen prey to sex trade and are treated as criminals rather than victims, their injuries are merely compounded. As such, this training is critical to ensuring that human trafficking victims are treated as victims and afforded justice and dignity. Secondly, H.R. 2473 establishes a working group to develop best methods to assess the prevalence of human trafficking. We know that there is a growing epidemic of the abhorrent practice of sex trafficking, and we must consider all methods to help law enforcement stop these crimes. The working group will identify methodological barriers hampering data collection on human trafficking, ascertain the information that should be collected, and identify current practices being used by different agencies and organizations that can be standardized into best practices. As a result, H.R. 2473 will help ensure the most effective prevention practices are standardized so that perpetrators of sex trafficking are ultimately brought to justice. And lastly, the legislation encourages states to adopt protections for victims of trafficking. Victims of sex trafficking are often very afraid to seek help, particularly from law enforcement, because of the risk that they will be treated as criminals rather than victims. 2473 recognizes the critical fact that children involved in sex trafficking are victims, not criminals. They absolutely should not be treated as criminals. Importantly, the bill identifies a broad range of initiatives that the states should undertake, including upholding basic rights and dignity of human trafficking survivors, facilitating ways to identify child trafficking victims and connect them with appropriate services, such as child welfare services, and providing emergency and long-term housing, as well as education, vocational, and job assistance and training assistance, among other services. For these various reasons, it's my pleasure to urge support for this bill. I thank the chairman and yield back the balance of my time.
Chair thanks the gentleman and now recognizes himself for purposes of offering an amendment. Clerk will report the amendment.
Amendment to H.R. 2473 offered by Mr. Goodlatte. Page 1, beginning.
Without objection, the amendment will be considered as read, and I will recognize myself to explain the amendment. This amendment to put the Put Trafficking Victims First Act of 2017 includes technical and substantive changes to the base bill that will help advance a victim-centered approach to human trafficking at all levels of government. Protecting children from the human trafficking industry is a critical component of this legislation. The amendment adds a section to the bill directing the Department of Justice to study the impact of state safe harbor laws on the re-victimization of child trafficking victims, the recovery of these victims, and victim outcomes. This report must include best practices and recommendations on the development and implementation of effective safe harbor laws that promote full recovery of child trafficking victims. Ensuring that child trafficking victims are treated the same as other child victims of rape, sexual assault, or incest is a major theme of this bill. No child should be criminalized for the evil committed against them, and our government has a duty to protect all children from abuse, especially including the vulnerable children who are in the child welfare system. The amendment, therefore, directs the Department of Justice to look at state safe harbor laws and determine how these laws are helping children avoid re-victimization. The amendment also ensures that survivors of human trafficking, experts on human trafficking, and representatives of organizations collecting data on human trafficking will be included in the expert working group on data collection that the bill establishes. In addition, the amendment provides clarification on the purposes of the nationwide survey to collect better data on the prevalence and trends of human trafficking in the U.S. The survey will also be used to assess how victims of trafficking are accessing services, how they are referred to services, how assessment tools work to identify victims of trafficking, and to help estimate the prevalence of human trafficking identification in the United States. The amendment also provides further instruction on the required report on mandatory restitution. The amendment asks the Attorney General to provide the annual number and percentage of federal cases related to human trafficking in which restitution was ordered and the amount of restitution ordered in each case. The report must also include data on the participation and non-participation of victims of trafficking in criminal proceedings and recommendations for encouraging such participation. Importantly, the amendment instructs states to adopt a survivor-centered approach to addressing human trafficking that ensures the safety and well-being of victims while recognizing the symptoms of trauma and coping mechanisms that may impact victims' interactions with law enforcement, the justice system, and service providers. Lastly, the amendment encourages states to make attempts to identify foreign nationals who may be victims of trafficking. Labor trafficking victims, especially those from outside the country, are very difficult to identify and are not always informed of their rights under U.S. law. State efforts to improve screening in this area would be hugely helpful. This amendment adds important provisions that will help advance better victim services in the United States, and I urge my colleagues to support this amendment.
Mr. Chairman.
The gentleman from Michigan seek recognition.
Mr. Chairman, I support the amendment.
Gentleman's recognized.
Would like to congratulate you on the clarifications that are included in your amendment and urge the support of the bill and yield back.
Mr. Chairman?
For purpose, the gentlewoman from California seek recognition.
To strike the last word.
Gentleman is recognized for 5 minutes.
Mr. Chairman, I do support this bill, but I do have some regrets that we're not doing more in this area than this bill would provide. Before I get into that, I want to congratulate the chairman and thank him for the amendment ensuring that all the victims of trafficking, whether they are legal residents, citizens, or undocumented foreigners, are going to receive services if they're victims of trafficking. That's very much in keeping with our past efforts, which were always bipartisan, to make sure that trafficking victims, no matter what their legal status, receive protection. And so I'm glad that the chairman has outlined that specifically. It's important, and I agree. However, and as I say, I will vote for this bill, but Mrs. Wagner's bill, introduced in January of this year, actually goes farther than this bill, meritorious as it may be. Mrs. Wagner's bill, which was a bipartisan bill, including co-sponsors on this committee, actually would have allowed trafficking victims to have their convictions expunged, providing a structure that would guide a court review for that expungement. I do think that ultimately we need to do that because, and I'm sure we've all, in our work in our districts, had occasion to meet individuals who are victims of trafficking. I know that I have in a forum that was held, sponsored by the County of Santa Clara, women who had been viciously abused and who, if you've got a conviction, a criminal conviction, because you were actually the victim, it prevents you from moving on with your life. It's a barrier to getting a job. And so while I say I agree that we should approve this bill and I support the bill, I'm hoping that at some point we can go one step further. Now I realize our jurisdiction is federal only, but we take our obligation to provide protections under the federal law seriously, and there is a secondary benefit when we amend federal law, and that's to provide models for the states. We did that when we did the Rape Victims Bill of Rights in the last Congress, understanding that most rape convictions are not in the federal court. We nevertheless stepped forward with that bill because it would provide protection for those few instances where the matters were in federal court, but it also would serve as a model for states all over the United States. And in fact, as we know, state legislatures have looked to that bill and they've taken it up and they've changed their state laws. And I think this is the same kind of situation. So as I say, the damage done to people who've been trafficked and then convicted of an offense because they were the victim, it's a double victimization. First, by the crime that was done to you, and second, the fact that you've got a criminal conviction that prevents you from actually moving on with your life. I wanted to mention H.R. 459, Mrs. Wagner's original bill, hoping that at some point we can move that forward for the reasons that I've outlined here today. And with that, Mr. Chairman, I would yield back.
Chair thanks the gentlewoman. Are there any amendments to the manager's amendment? For purpose of the gentlewoman from Texas seek recognition.
I'd like to strike the last word.
Gentlewoman's recognized for 5 minutes.
I want to thank the gentlelady from California for her comments. I want to make a general statement about 2473. As you well know, much work has been done on human trafficking from those of us from Houston, and in particular, Judge Poe, our colleague, has been working on this issue through the Judiciary Committee, and I have been working on it through the Homeland Security Committee, and we came together for a committee hearing about 2 years ago in Houston, the first congressional hearing on human trafficking. Houston has been called the epicenter of human trafficking, and Mr. Chairman, ranking member, when we went to the Harris County Jail during the police working group meeting, we heard from women who had actually been trafficked. It is real, it is visible, and I believe that the underpinnings or the premise of this legislation is important, which in particular requires the training for prosecutions of traffickers, develops methodology to assess prevalence of human trafficking, and a report on prosecutors seeking mandatory restitution. The bill appears to be victim-centered proposal, and I'm pleased that it includes foreign nationals as well as legal permanent residents and citizens, taking into account the comments of the gentlelady from California. At least want to move this legislation forward because I've seen firsthand that victim assistance is paramount, as many of these victims have suffered sexual abuse and are forced into the black market to engage in unlawful acts that are detrimental to their mental and physical health, and it is done over and over again, and also damaging to their ability to regain a sense of normalcy. It is essential that we address the issue of trafficking in a broader scope if the goal is to help these victims reclaim their identity, dignity, and their ability to move forward with a productive and healthy life as new members of our society. With the spike in T visa issuance since its enactment in 2000 by Congress, it's clear that there is a great need to expand protections for victims of this modern-day slavery. I hope that this will be one bright light today, including the previous bill that we are engaging in the Judiciary Committee. These victims need as much help as they can get, and I certainly ask my colleagues to support the legislation. I yield back.
There's a gentleman from Georgia seek recognition.
Move to strike the last word.
Gentleman's recognized for 5 minutes.
Mr. Chairman, I want to support H.R. 2473, and I hope my colleagues on this committee will give this bill our full support. This bill modifies the 2015 Justice for Victims of Trafficking Act and empowers victims of trafficking. Specifically, the bill amends the JVTA to provide training to prosecutors and investigators towards the processing of cases with trauma-informed and victim-centered approaches. And the bill offers encouragement to states to provide appropriate services to victims of trafficking. This is a thoughtful bill and one that considers how we implement the remedies we secure for victims of these crimes. So I applaud my colleague, Mrs. Wagner, for this bill, and I intend to support it, and with that, I yield back.
Who seeks, for the purpose, the gentleman from Texas seek recognition.
Mr. Chairman, I move to strike the last word.
Gentleman's recognized for 5 minutes.
Speak on the legislation. As we all know, this is trafficking, human sex trafficking is a scourge on our society. Congress 2 years ago, in a very bipartisan way, overwhelmingly approved legislation out of the House, went to the Senate, changed a little bit, and the Justice for Victims of Trafficking Act is now the law of the land. And this legislation by Congresswoman Wagner helps the country understand that this scourge of sex trafficking is going to be addressed. The training portion in here is very good. I met with some prosecutors in Texas last week and discussing the trafficking, human trafficking. And one of the issues that they mentioned was that there needs to be more training of those people in the business of prosecuting these traffickers and the buyers and rescuing and restoring victims. There needs to be training for law enforcement and training for those who prosecute these devils, if I can use that phrase, and also help understand more about victims because they're a unique type of victim because of the tremendous harm that has already been inflicted on them, not only physically, but emotionally, and those folks have to have someone, and that's us, rescue, restore, and treat them like the dignity that they need. So I applaud the legislation, and I hope that we see that it pass and keep the awareness by Congress on the forefront that we are going to deal with this scourge of human trafficking. Thank you, Mr. Chairman. I'll yield back.
Chair thanks the gentleman. For purpose, the gentlewoman from California seek recognition.
Mr. Chairman, I have an amendment at the desk.
The clerk advises that we do not yet have the amendment, and it's also our understanding that you actually have two amendments.
I do. I think you have the amendment now.
One is an amendment to the manager's amendment, and one is an amendment to the underlying bill. So we'd like to take up the amendment to the manager's amendment first, and we're on a search for finding it.
Amendment to the Goodlatte Amendment to H.R. 2473 offered by Ms. Bass of California. On page 2, strike the amendment.
Without objection, the amendment be considered as read, and the gentlewoman is recognized for 5 minutes on her amendment.
Thank you, Mr. Chair. The purpose of my amendment is to better identify and screen the characteristics of children and youth involved in the child welfare and justice system, and to provide greater access to appropriate housing and services from trained, trauma-informed care service providers. Mr. Chairman, I want to thank my colleague, especially my colleague Ann Wagner of Missouri, and the efforts of all of those who have come together to put forth legislation and policy solutions that will eliminate barriers of relief and justice for victims of trafficking and strengthen systems of accountability for perpetrators. Traditional bipartisan support on critical issues and efforts to combat human trafficking cannot be overstated or diminished. The progress we have made working together over the past few years has been vital, but the work is far from over and must continue. In particular, we must continue to draw awareness and find solutions to eradicate the devastating impact of young children who are in the U.S. child welfare system from becoming victims of sex trafficking. And I want to mention to my colleagues that the purpose of the child welfare system is to protect children who are abused or neglected. When we take custody of these children, then we, meaning the local county or state government, we in effect become the parents. So if our own child shows up missing and we don't do anything about it, then we are responsible. And this is exactly what is happening with child sex trafficking in the United States. A large percentage of the children, predominantly girls, but some boys as well, are kids that fall through the cracks of our child welfare system. I support H.R. 2473 because this bill calls for the necessary training and data collection assessments to help identify and implement effective and responsive models of justice and relief services. Specifically, my amendment would strengthen these efforts by including in the agency report to Congress detailed characteristics of victims of trafficking in the child welfare and justice systems, including factors such as the age, which we know anecdotally is the average age is 12 years old, race and gender of the victim, whether the victim has involvement in the child welfare or justice system, the number of foster care or congregate care placements, and whether the individual is a victim of sex or labor trafficking, and the effectiveness of current policies and procedures in meeting victims' needs for appropriate housing. We have been told repeatedly that one of the reasons why the girls will go back to their pimps is because they basically have no place to live. So given that these are girls that we are responsible for, we need to look at the appropriate housing and services from trained trauma-informed care service providers. And in developing this report, we want additional input from sex and labor trafficking service providers. My amendment would further encourage states to implement screening mechanisms for all children entering child welfare services and the criminal and juvenile justice systems to better identify child trafficking victims and connect them with appropriate services, especially appropriate housing and services from trained trauma-informed care service providers. And lastly, my amendment would include, as part of the training provided to prosecutors of traffickers, an emphasis on training for prosecutors to effectively prosecute traffickers and buyers of child sex trafficking. I urge my colleagues to support the adoption of the amendment. Thank you, and I yield back.
Would the gentlewoman yield?
Yes.
I thank the gentlewoman for yielding, and I want to thank her for her work on this amendment and for working with the committee staff and for working with Ms. Wagner, and I support your amendment, and I urge my colleagues to do the same.
Thank you, Mr. Chair.
Mr. Chairman.
For the purpose of the gentleman from Pennsylvania, seek recognition.
Strike the last word.
Gentleman is recognized for 5 minutes.
Thank you. I'm wholeheartedly supportive of this amendment from my colleague. We both do a great deal of work. We co-chair the Foster Youth / Adoption Caucus, and there's no one in this country that knows more about foster care, what these children need, how they are abused. There's no one that knows what my good dear friend from California, Karen Bass, realizes and has been a leader in not only legislation, but promoting foster care. So I urge my colleagues to support this, and I want to thank my good friend for this amendment. I yield back.
Mr. Chairman.
What purpose the gentleman from Michigan seek recognition?
To support the amendment.
The gentleman is recognized for 5 minutes.
And I join in with the accolades that are coming toward the gentlelady from California, because I think it provides helpful additions to the chairman's own proposal, and I thank her so much.
Chairman?
For purpose the gentlewoman from Texas seek recognition?
I rise to strike the last word.
Gentlewoman is recognized for 5 minutes.
Let me as well congratulate the gentlelady from California and added congratulations for her persistent contributions to the care of foster care children, particularly when they are, in fact, as she said, we or the state or the government becomes their guardian, becomes their caretaker. Next week, she will allow many of us to have a foster care student or a foster care young person follow us. I've done it for a number of years. And so I want to thank she and both Ms. Marino for the Foster Care Caucus. I hope that we'll have a time in Houston for them to be there. But we see this as, again, Houston is a great city with great opportunities, but we also see a high number of runaways who either in the system or get into the system, and they are very vulnerable to human trafficking. They are sadly being hunted, if you will, because they have no place to go. They may have left a foster care setting, but they're still under the jurisdiction. I might add that Congressman Bass has been very effective in noting for those who age out. So her amendment will be very helpful to focus and pointedly respond to these youngsters who are particularly vulnerable, and I rise to support the gentlelady's amendment. With that, I yield back.
Question occurs on the amendment to the amendment. All those in favor respond by saying aye. Aye. Those opposed, no. The amendment is agreed to. The gentlewoman from California is recognized for her other amendment. Oh, I'm sorry, you're correct. So the question now occurs, are there further amendments to the manager's amendment? Being none, the question occurs on the manager's amendment. All those in favor respond by saying aye.
Aye.
Those opposed, no. The ayes have it, and the manager's amendment is adopted. Now we'll turn back to the gentlewoman from California for her other amendment.
Thank you, Mr. Chair. I have another amendment at the desk, and it makes several minor revisions to include the training of prosecutors.
Gentlewoman would suspend. We first need to report the amendment, and I think there may be a delay here. think it is. Is it? The clerk will report the amendment.
Amendment to H.R. 2473 offered by Ms. Bass of California. Page 3,
Without
line 1.
objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on her amendment.
Mr. Chair, I understand that there are some technical revisions that need to be made, and I will agree to withdraw my amendment.
The chair thanks the gentlewoman and will be happy to work with you on fixing this on the way to the floor.
Thank you.
Without objection, the amendment is withdrawn. And are there further amendments to H.R. 2473? A reporting quorum being present, the question is on the motion to report the bill H.R. 2473 as amended favorably to the House. Those in favor respond by saying aye. Aye. Those opposed, no. The ayes have it. The bill is ordered reported favorably. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 2431 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2431, to amend the Immigration and Nationality Act to improve immigration law enforcement within the interior of the United States and for other purposes.
Without objection, the bill is considered read and open for amendment at any time. I will begin by recognizing myself for an opening statement. In the 100 days since President Trump signed executive orders making sense of our nation's immigration enforcement priorities, U.S. Immigration and Customs Enforcement has increased immigration arrests 38% over the same period last year. Nearly 75% of the arrests were of convicted criminals. The combination of revised enforcement priorities and actual enforcement has had significant results. In February, the Border Patrol recorded a 40% drop in unlawful entrance along our borders. After 8 years of neglect by the Obama administration, the realization that the Department of Homeland Security will actually enforce our immigration laws has made aliens think twice about violating our borders and our immigration laws. And it was said that trying to control our borders was simply tilting at windmills. These promising signs must be accompanied by Congress giving immigration officers the additional tools they vitally need to do their jobs and keep themselves safe. If we act responsibly, we will conclusively demonstrate that this country will not tolerate the flagrant disregard of our laws and our hospitality, especially by those who threaten our safety and security. For too long, the administration has viewed immigration enforcement with disdain and its own immigration officers with contempt. Under the Obama administration, the number of removals from the interior of the United States declined precipitously, as did the number of removals of criminal aliens, despite ever-increasing resources and inexplicable reports to the contrary. Under the guise of prosecutorial discretion and so-called enforcement priorities, removable aliens were essentially free to roam our country unless they had been convicted of an ever-narrowing list of offenses. Through the use of unconstitutional executive orders to create a Congress of one, President Obama substantially hobbled ICE's enforcement capabilities and prevented its dedicated public servants from carrying out their critical mission. We are still feeling the effects of years of non-enforcement. In March, in my own district, a Lynchburg teenager was murdered by gang members believed to be in this country illegally. Even more disturbing, one of the alleged killers had an outstanding warrant in connection with a previous murder in Maryland. As killers and other dangerous individuals walk free, sanctuary jurisdictions that were encouraged to obstruct immigration enforcement by the previous administration hold resolute in their conviction that immigration enforcement is wrong. This country is in desperate need of new statutory tools to enforce our immigration laws. H.R. 2431, the Michael Davis Jr. and Danny Oliver in support of State and Local Law Enforcement Act was introduced by Immigration and Border Security Subcommittee Vice Chairman Raul Labrador. The bill decisively delivers the immigration enforcement tools that ICE, its officers, and all of us need in order to show the obstructionists, the criminal aliens, and all those who benefit from a culture of lawlessness that breaking our immigration laws will no longer be tolerated. It is named after 2 law enforcement officers who were murdered by an illegal alien. I know we were all deeply honored to have their widows attend the State of the Union address as guests of President Trump. Mr. Labrador's bill provides the Department of Homeland Security and specifically ICE with the tools it needs to protect our communities and enforce our immigration laws in the way Congress always intended. In addition, it reverses disastrous policies by the previous administration and ensures they are never again instituted by another administration. Mr. Labrador's bill gives states and localities the explicit congressional authorization the Supreme Court requires for them to enact and enforce their own immigration laws, provided they are consistent with federal law and robustly assist in the enforcement of federal law. Real immigration reform needs to have a mechanism to prevent any president acting alone from simply turning off the switch on enforcement. This bill ensures that when the federal government fails to act, states can, if they so choose, pick up the slack. H.R. 2431 takes giant steps in protecting jurisdictions that comply with detainers so that ICE can take custody of removable aliens they have arrested, such as by protecting them from abusive lawsuits. And it makes clear that sanctuary jurisdictions will face the consequences of their irresponsible and unlawful actions, such as by losing federal law enforcement and Homeland Security grants, and by becoming liable for damages to the victims of crimes committed by the aliens they have released. By expanding the types of serious criminal activity for which we can remove aliens, including drunk driving, failure to register as a sex offender, and criminal gang membership, the bill sends a strong message that criminal aliens will not get a free pass. H.R. 2431 is a comprehensive enforcement package that provides ICE and our states with the tools and the congressional blessing to bolster current immigration enforcement efforts and reverse the non-enforcement of the past. I thank Representative Labrador for championing this issue, and I urge my colleagues to support this bill. It is now my pleasure to recognize the ranking member of the Judiciary Committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Members of the committee, this is a troubling matter that we have in the form of this amendment. And I've seen a lot of things that I've disagreed on, but this has been a proposal before us now that is, to put it very simply, an anti-immigrant bill. It expands an already massive federal agency. It threatens local governments to do the federal government's bidding, and it intrudes on the privacy rights of average Americans. It also violates our values as a nation of immigrants and harms communities across the nation. Now, among the shortcomings of this measure, it makes it a crime to be undocumented in this country. And this is not the kind of solution our nation needs. I've also noticed that by granting local officers unprecedented and unchecked authority to enforce federal immigration laws, the bill will actually make our communities less safe. Studies show that when police officers become immigration agents, crime victims and witnesses fear coming forward. Crime goes unreported, and public safety suffers. And if states and localities decide the best way to promote public safety and community policing is to adopt policies regarding the immigration enforcement action of police, this bill denies those jurisdictions Cops on the Beat program, Cops on the Beat grants. It denies them. Those are grants specifically designed to promote public safety and enhance community policing. And so that's why the proposal that is now before us, my colleagues, has been opposed by the Major Cities Police Chiefs Association and the Law Enforcement Immigration Task Force. It's also been opposed by the National Conference of State Legislatures, the United States Conference of Mayors, the National Association of Counties, the National League of Cities. This legislation will result in widespread racial profiling and unconstitutional arrests of United States citizens and immigrants alike. How do we know this? Because this is what happened in jurisdictions across this country that entered into 287G agreements with the Department of Homeland Security. We saw it in Maricopa County, where a federal judge found that Sheriff Joe Arpaio engaged in a pattern of racially profiling Latinos. We also saw it in Alamance County, North Carolina, which had its 287G agreement terminated based on findings of abuse by the Department of Justice. According to the Department of Justice complaint, the Alamance County Sheriff explicitly ordered his staff to, quote, go out there and catch me some Mexicans, unquote, and directed deputies to arrest Hispanics, but not others, for minor infractions. So what does this bill do? Well, rather than improve on current practice and require more oversight over 287G agreements, it grants total enforcement authority with no checks at all. So this legislation represents a significant down payment on Donald Trump's mass deportation plan. It is singularly focused on the widespread location, detention, and deportation of millions of immigrants and would cause untold harm to American communities. And so for those reasons, my colleagues, I urge that we reject this mean-spirited and dangerous legislation. I thank the chairman.
Thank you, Mr. Conyers. I'd now like to recognize the sponsor of the bill, Mr. Labrador of Idaho, for his opening statement.
Thank you, Mr. Chairman, and thank you for holding this important markup today. The United States of America is the greatest nation in history. We are the greatest nation because we are a nation of laws. In America, it is foundational principle that all individuals are treated equally under the law, whether you are rich or poor, famous or unknown. Unfortunately, for 8 years, President Obama's refusal to enforce our immigration laws undermined the rule of law. And by undermining the rule of law, he diminished the strength of the United States. Fortunately, President Trump has reversed those directions, and law enforcement is once again enforcing our immigration laws. In fact, President Trump owes his position to the promise he made to the American people to get serious about enforcing our laws. America is our home, and the American people expect us, as their elected representatives, to do all that we can to keep our communities safe and secure. For too long, we have allowed individuals to enter our country illegally, and too many cases do us harm. In fact, maybe this is news to the people on the other side, but it is already a crime to be in the United States illegally. It's already been set in law. This bill, the Davis-Oliver Act, will ensure that the law will be enforced no matter who is in the White House. The bill is named after 2 California officers, Placer County Detective Michael Davis Jr. and Sacramento County Deputy Sheriff Danny Oliver. Davis and Oliver were murdered by an illegal immigrant in October 2014. This bill is intended to ensure that other families do not suffer as victims of crimes committed by individuals who should not have been allowed to enter or remain in a country in the first place. Since being elected to Congress in 2010, I have made it a priority to work towards modernizing our immigration system. But the first and most crucial step in that process is ensuring enforcement of our current laws. The Davis-Oliver Act takes that first and necessary step. While other reforms are needed, this bill is vital to a long-term fix. That is why I am honored to introduce the Davis-Oliver Act. This bill authorizes state and local law enforcement to work together with our federal immigration officers to provide meaningful enforcement of the law. This is not a new concept. In fact, we currently allow state and local law enforcement to assist federal law enforcement in many areas. And the record shows that we can achieve remarkable results when state, local, and federal law enforcement work together. This is a critical first step to ensuring the American people feel confident that our laws are being enforced. Allowing state and local law enforcement to assist in the enforcement of our immigration laws will ensure that no matter who is in the White House, our immigration laws will be followed. To help state and local law enforcement assist federal law enforcement, this bill provides grants to allow state and local police agencies in procuring equipment, technology, facilities, and other products that facilitate and are directly related to investigating, apprehending, arresting, detaining, or transporting aliens who have violated our immigration laws. Additionally, the legislation requires DHS to create training manuals and guides for the training of state and local officials to ensure that the laws are being enforced uniformly across jurisdictions. The Davis-Oliver Act also takes steps to end the harmful practice of states and localities refusing to comply with federal detainers and encourages states and localities not to adopt dangerous sanctuary policies by predicating receipt of funding on cooperation with immigration officials. The Davis-Oliver Act improves visa security by expanding the visa security program to all U.S. embassies and consular posts. This will ensure that all visa applications receive the screening that they deserve. Finally, the bill provides ICE officers with the equipment and training they need to safely and effectively enforce our immigration laws in this dangerous world. I am proud of this legislation and pleased that this committee has started the process of reforming and modernizing our immigration system. Once we have taken the necessary steps to ensure that our immigration laws are enforced, I look forward to completing the next steps in the immigration reform process. And with that, I yield back.
Chairman.
Thank you, Mr. Labrador. At this time, I'd like to recognize the ranking member of the Immigration and Border Security Subcommittee, the gentlewoman from California, Ms. Lofgren, for her opening statement.
Thank you, Mr. Chairman. Proponents of this bill say that it's necessary to keep us safe. But what the bill really does is pander to the noxious notion that immigrants are criminals and should be dealt with harshly. As we know, the truth is that immigrants commit crime at a far lower rate than native-born. They add greatly to the country's wealth, both by working in agriculture, technology, medical care, housing, and other critical sectors of the nation's economy, and by operating small businesses in every corner of this country. But in Trump's America, we're told not to trust the news, that climate change is a hoax, less health care coverage is better health coverage, and that immigrants are dangerous. The real danger, of course, is making policy based on alternative facts. Based on alternative facts, this bill would turn all undocumented immigrants, including dreamers, parents, and children, into criminals overnight, and it would empower local law enforcement with little training in the area to engage in overreaching witch hunts, replete with racial profiling and violations of civil rights. It's no surprise that this bill was on Steve Bannon's whiteboard as a priority for the Trump administration. This bill gives Trump and Bannon the legislative authority to establish their massive deportation force and would turn our communities into police states overnight. This bill should really be called the Trump Mass Deportation Act, because that's what it is. This bill will make us neither safer nor more prosperous. Since Trump's inauguration and the issuance of his executive orders, we've seen a sharp decline in international visitors, fewer foreign students seeking to study here, and ripple effects in our technology sector. Whether intended or not, Trump has set the international message: the United States is closed for business and our economy is paying the price. After the executive orders, we've also seen decreasing levels of crime reporting within Latino communities. This is not a good thing. Law enforcement officers and prosecutors all over the country know that if residents are too afraid to come forward to report crime or testify against criminal activity, their communities, our communities, will be less safe. If this bill is enacted into law, criminal activity in our communities will only escalate, as criminals will be allowed to commit crime with impunity. The bill simply casts aside these inconvenient truths in the rush to target and expel immigrants. The Constitution fares no better. Despite my colleagues' professed adoration for the Constitution and limited government, this bill raises severe constitutional concerns. There are provisions that turn immigration law on its head by allowing states and localities to enact their own immigration laws and penalties and to independently enforce them. These include the authority for local officials to investigate, arrest, and even detain individuals they suspect have violated civil immigration laws, all without any coordination with federal authorities. Perhaps more pointedly, the bill puts states and localities in de facto control of federal enforcement by giving them the power to order federal officials, without exception, to arrest and detain individuals suspected by local officers of violating immigration laws. Giving local officers the authority to commandeer federal enforcement resources intrudes on core executive powers and raises significant separation of powers and federalism concerns. There are also provisions authorizing the indefinite and possibly permanent detention of persons who cannot be removed despite their cooperation with removal efforts. This provision would overturn the Supreme Court's decision in Zadaveas versus Davis, where the court strongly suggested that such detention would violate bedrock constitutional protections. Again, I ask why we feel compelled to violate the Constitution despite a professed loyalty to our Constitution. I'm left wondering whether anti-immigrant rhetoric has so invaded some of us that we're no longer to embrace fundamental ideals embodied in our Constitution. It was not too long ago that my colleagues on the other side of the aisle and I were able to have reasonable conversations about immigration policy. While we disagreed on many things, we shared certain core beliefs that allowed us to work on common sense bipartisan solutions. This bill is not a solution. It's the wrong direction for our country, and I hope that we can at least make some of it better through a series of amendments that we will offer, Mr. Chairman. I would also, if I may now, ask unanimous consent to enter into the record several statements. A statement from the Hebrew Immigrant Aid Society, a letter signed by 85 legal law professors and scholars of constitutional immigration law, a letter from the Leadership Council on Civil and Human Rights, a statement by America's Voice, a statement from the American Immigration Lawyers Association, a letter from the National Center for Transgender Equality, a statement from the ACLU, a statement from Church World Services, a statement from the Friends Committee on National Legislation, a statement signed by 27 members of the Law Enforcement Immigration Task Force, a statement on behalf of 22 child advocate organizations, a statement on behalf of 25 refugee advocate organizations, a letter signed by 192 national, state, and local religious, civil rights, ethnic, and immigration organizations, a statement from the U.S. Conference of Catholic Bishops, a statement from the Cato Institute, a letter from the Coalition for Humane Immigration Rights, a letter of opposition from the National Task Force to End Sexual and Domestic Violence, a letter of opposition from the Network Lobby for Catholic Social Justice, a letter of opposition from the Franciscan Action Network, a letter of opposition from Disciples Home Mission, a statement of opposition from Jim Wallace, the president and founder of Sojourners, a statement of opposition from the National Justice for Our Neighbors, a statement from Global Jewish Advocacy, and finally, a report setting the record straight on local involvement in federal civil immigration enforcement, May 2007, from the New York State Office of the AG from California, the District of Columbia, Oregon, Rhode Island, and the state of Washington.
Without objection, these documents will be made part of the record. Are there any amendments to H.R. 2431? What purpose the gentlewoman from...
Strike the last word.
Seek recognition. Gentlewoman is recognized for 5 minutes.
Mr. Chairman, I rise in opposition to this legislation, and I make a particular point of acknowledging the tragedy surrounding the naming of the legislation, and believe that we can collectively honor individuals in a way that will address, as Mr. Conyers has said, the immigration reform process that enhances eliminating criminal activity or criminal acts that would generate in tragic incidences. But this is not this legislation, and I think it is very honest to say this is a campaign pledge, and it is the one of Mr. Trump for a deportation task force. More importantly, it is a reinstatement of mass incarceration. It is a promoting of where the federal prison system has been so effective in safely diminishing or decreasing the number of incarcerated persons. This legislation steps in to cure those empty beds and to increase the amount of money the American people will pay, and to divide families and to endanger children. And so just for an example, if I take Section 314 and I look at a number of sections in 314, you will see one section adds 10 years. Another section adds 15 years. Another section adds 20 years. And this may be on top of, Mr. Conyers, the sentencing that have already occurred. And so this will be the new fodder and raw material for the nation's private prisons and the federal prison system. It also violates the known principle and division of work, if you will, of now giving over to the states and local governments' immigration duties of enforcement. There is nothing that will create more hostility in a community than to engage the local law enforcement unwillingly into immigration enforcement. And my chief and others have indicated that is not their job. And the way to keep the city and counties safe is that everyone is free to point out the criminal and the crime. In addition, let me add another great concern. And I want to put the Houston Detention Center on notice of my concern. And that is the number of deaths that have occurred, and we have discussed this in this committee, in the detention centers around the nation. Deaths that were unwarranted and occurred because of negligence. Some of these are private detention centers. Far be it from me to challenge someone's economic opportunity or the employees. Many of them are ex-Federal of Prison Bureau employees. I know their intentions may be good, but intentions cannot bring back the dead, or good intentions. And so it is very clear. Medical experts evaluated 18 deaths from May 2012 to June 2015. During those 3 years, at least 21 people died in ICE custody, but ICE released investigations only on half of those cases after a Freedom of Information court battle. And so it is clear that this bill is racked with large gaping holes of responsibility and the right way to look. Now, let me just say that some who have advocated for this bill have joined us on comprehensive immigration reform in times past. I'm sorry that it has come to this, that this is now the offering. No one can accept this bill. This will not be acceptable. And frankly, the numbers of those coming across the border are down. And the only people that we will be attacking in this bill are the 11 million plus that have been sitting and waiting, working and praying that we would have comprehensive immigration reform so they could continue to own homes, pay taxes, and yes, follow the law.
The gentlelady's
All this
time
bill
has
does
expired.
is increase mass incarceration. I yield back.
Gentlelady yields back. Time's expired. Does any other member seek recognition? The gentleman from Georgia is recognized for 5 minutes.
Thank you, Mr. Chairman. I must strenuously object to this Steve Bannon, Donald Trump deportation bill. This bill is the culmination of every hyperbolic and despicable thing that Steve Bannon and President Trump have said about immigrants, both during and after the recent campaign. This piece of legislation does absolutely nothing to address the problem of individuals and families living in the shadows. It criminalizes undocumented status. It goes after so-called sanctuary cities. It expands detention policies, and it ramps up the militarization of local and state police departments. I will when I finish. Additionally, this bill and the mean-spiritedness about it perpetuates what we know are alternative facts. The fact is, immigrants commit crimes at lower rates than their natural-born counterparts. Lastly, this bill hurts all Americans. The fact is that since this president took office, travel to America has declined, educational visas have declined, and Americans are being caught up and ensnared in immigration dragnets, which are terrorizing communities across this nation. Whether it's federalism or morality, this is a bad bill. This bill should be known as something that is a panacea to the private prison industrial complex, the for-profit private prison industrial complex, where detainees are held for months awaiting proceedings, because of the bottleneck created by the lack of immigration judges. So you create a bottleneck down at the bottom, and then you create a wide funnel at the top, and you drag people into these detention centers, hold them for months under conditions that have been described as being brutal and inhumane. In fact, there have been 2 deaths in ICE custody just over the last few days, and just in Georgia, 2 inmates have died in custody, in ICE custody. And what this bill does is tries to open up more floodgates to bring more detainees into the system, because what did Congress do? Upped the number of beds that it pays for, that it pays these private prison companies for. 39,000 beds are now being paid for by the U.S. taxpayers, and those beds are paid for regardless of whether or not anyone is in them or not. So the move is to put more bodies in those beds, if you could call them beds. And so this bill, like I said, is a panacea for the private prison industrial complex. And I urge my colleagues to reject this bill, not just on fiscal grounds, but on morality and humanity grounds. With that, I will,
Will the gentleman yield?
I will.
I'm trying to better understand the gentleman's comments when he says the legislation criminalizes undocumented status. Is there anyone with undocumented status that is not an illegal immigrant?
Well, you can characterize them how you like, but people who are attracted to this country to be exploited
Would
for
the gentleman
labor.
yield? Would the gentleman yield?
Yes, I will.
Thank you. I just want to say, undocumented aliens, unless they've committed criminal offenses of various natures, their undocumented status is a civil, not a criminal offense. This bill would change that, and that's the answer to your question. I yield back.
All right, thank
Will
you.
the gentleman yield?
And with that, I will, my time is about to run. Someone else can yield.
Mr. Chairman.
I yield
The
back.
gentleman's time has expired. Does anyone seek recognition?
Mr. Chairman.
The gentlelady from Washington is recognized.
Thank you, Mr. Chairman. This bill, we have to call it Trump's Mass Deportation Act. That is what it is. It is a harsh, anti-immigrant, enforcement-only proposal that would criminalize all undocumented immigrants, undermine public safety, and harm the American people and waste millions of dollars. And here is the true statement in response to some of the discussion before. It is not a true statement that being in the country illegally is a crime. Here is what is true. Illegal entry is a misdemeanor offense, but it is not a continuing offense. What that means is that if you are not charged within 5 years, the government cannot prosecute you for this offense. And this has been the law for decades. The majority of undocumented people in this country would not be able to be prosecuted and could not be convicted of any immigration-related crime because most of them have been here for a very long time. So let us be very clear on what the facts are. Mr. Chairman, this bill is a play to prejudice. It is a welcome mat to racism, and it is a repudiation of the very values that have defined our great nation since our inception, values that are inscribed on the Statue of Liberty, values that brought the ancestors of every person in this chamber to this country, unless you were Native American. And I am not sure what we have forgotten in this country when we put a bill like this forward that would literally be a mass deportation force and a criminalization of undocumented immigrants that would ensnare dreamers, some DACA recipients, and permanent residents even into this dragnet. ICE's first 100 days under the Trump administration have been a disaster for families and communities all across the country. Without any attempt to prioritize those who are a true threat to communities, ICE has significantly increased the numbers of people swept up by Trump's deportation force, including dreamers, parents of U.S. citizens, and survivors of domestic abuse. Even while they claim to be targeting, quote, bad hombres, ICE's own statistics show a significant and worrying jump in people with no criminal records being put into the enforcement machinery. And what's worse, Trump and some of my Republican colleagues want to supercharge this deportation force with more money, more funding, and more weaponry. Mr. Chairman, I really believe that this country is desperately in need of something, but it is not statutory tools for mass deportations. That's not what we're in great need of. What this country is in great need of is true, comprehensive, humane immigration reform. That is what many of us have been working on for a very long time. And the idea that we would put forward a bill like this when we have so much to do on this committee and the Immigration Subcommittee on real responses to what is happening across this country that is creating crises in our schools, in our homes, for our families across the country, to me is a travesty. Now, even if you didn't believe in the morality of this issue, let me just say what the economics would show. Deporting just 7 million undocumented workers out of the 12 million total would result in a 2.6% reduction in GDP, taking $4.7 trillion out of the economy. If all undocumented workers were deported, we would lose nearly $5 trillion in economic growth over 10 years. And increased enforcement of the nature proposed in this bill would increase the price for a gallon of milk up to $8. It would increase food prices by 5 to 6%. It would decrease domestic food production by 30 to 61%. Agricultural output would fall by $30 to $6 billion, and lost production in the livestock sector would drop by 13 to 27%. Why is that? It is because undocumented immigrants and immigrants across this country serve our country every single day. They put food on the table, they allow us to do the work we need to do, and it is a travesty that we would put forward a bill that would somehow make it seem like undocumented immigrants and immigrants in general to this country are doing us harm. That is not what the statistics show. And Mr. Chairman, I would like the opportunity to submit for the record 2 letters, one from the King County Prosecuting Attorney's Office that specifically talks about the harm that would be done to domestic violence victims, sexual assault victims, those who we proposed bills to support earlier in this session, and also a letter from the U.S. Catholic Conference of Bishops, the Committee on Migration, and specifically it says, we believe that together these bills would constitute an unacceptable expansion in immigration enforcement that would contravene the principle of treating all individuals with human dignity regardless of their immigration status. Mr. Chairman, I yield back.
Without objection, so ordered, and the gentlelady's time has expired. The gentleman from Florida, Mr. Gates, is recognized for 5 minutes.
Thank you, Mr. Chairman. And I object to the categorization of illegal aliens as undocumented. Undocumented just sort of makes it sound like some people lost some paperwork or didn't cross some T's or dot I's. This is illegal immigration. And it's preposterous on this committee that Democrats take the position that illegal immigration isn't illegal. It's something else. Or that a misdemeanor is not a crime. It in fact is. And the only reason that we're unable to prosecute people 5 years after they break the law to get in the country is because the statute of limitations is run. That doesn't mean that they're here legally. That doesn't mean they haven't committed a crime. It just means that during the Obama presidency, there was such an abandonment of a focus on enforcement that we allowed these opportunities to enforce the law to lapse. And so I associate myself with the comments of the bill sponsor, Mr. Labrador, when he says that this is about the rule of law. And if the very first thing people do to get into this country is break the law, we have substantially eroded that which is special about the United States of America. And so I strongly support the legislation on those grounds. There are also strong economic bases to reject illegal immigration as an economic development tool. The comment was made that, well, we've got all these undocumented people who are working, and if we lose them as workers, that has an impact on the economy. Well, if they're undocumented, how did they get the documents to work? In most circumstances, they've stolen them, they've fabricated them, they've acquired them through improper means. And so it seems to be quite the double bind for Democrats who simply want to invite illegal immigration in this country to say that, well, it's this great economic additive, while at the same time referring to illegal immigrants as undocumented. There's substantial evidence that indicates that the economic cost of illegal immigration is significant. Conservative estimates indicate that it could be well over $100 billion a year. Illegal immigrants show up in our schools, our hospitals, they utilize social services. And this isn't to say that immigration is not a great source of good for the country. It is. And I think that Mr. Labrador's legislation acknowledges the fact that if people come to the country legally, make a contribution, the United States will always be the most welcoming country on earth towards those objectives and goals and values. But what we will not value is breaking the law, and what we should not do is create euphemisms for lawbreakers, and that's why I support this legislation.
Will the gentleman
I yield
yield
back.
for a question?
Sure, certainly.
I would just ask my friend from Florida a simple question, and I listened to the speech, and I'll refrain from commenting until I move to strike the last word. But I'm trying to understand. I'd like to distill this all down to where I think you're going, but I can't imagine you're really going, which is there are 11 million people, human beings in this country, who are undocumented. You don't like the phrase. You can call them whatever you want. They're human beings. Is the goal of my friend from Florida to round up 11 million people who are living in our communities, so many of them contributing for years in our communities, including kids who have grown up in this country, have known no other country other than America? Is the goal to round up those people that you describe as illegal and to deport those 11 million people? And if that's the goal, is the goal to accomplish it all at once, or will you be satisfied doing it in tranches of perhaps 50,000 at a time?
I don't call these people illegal. They are illegal. They are here illegally, which was the point of my remarks.
Should they be deported, all 11 million, all at one time?
Well, I think the focus of Mr. Labrador's legislation is to ensure that the resources are available for our local law enforcement, state law enforcement, to ensure that those who are the most dangerous draw our focus. So no, this legislation is not intended to deport 11 million people, but it certainly draws into sharp relief the need to enforce the rule of law in this country.
If we had the resources to do it, would you support deporting 11 million people?
Well, I tell you what, I always enjoy bipartisan work with my dear colleague from Florida, and so if you would like to work together on a mechanism to better enforce the rule of law and direct resources to get people who are not here legally back to their home countries, I'd be eager to work with you on that.
Does the gentleman yield back?
I yield back.
Gentleman yields back his time. The other gentleman from Florida, Mr. Deutsch, is recognized.
Thank you.
For
Move
5
to
minutes.
strike the last word. Thank you, Mr. Chairman. I would just say to my friend from Florida, I will never, much as I enjoy working with him, I will never spend a moment's time trying to figure out how to put in place a policy that is inhumane and un-American, that calls for rounding up 11 million people and shipping them out of our country. No. On that one, I will not work with my friend. Mr. Chairman, this bill that we have before us is an enforcement-only immigration bill. The bill would make it a crime to be in the United States as an undocumented immigrant. It would expand the ability to revoke non-immigrant visas without judicial review. It would make detention facilities less safe for families and small children. It would significantly increase the number of ICE officers and militarize them with assault weapons. It would have local law enforcement officers enforce our nation's immigration laws. It would impose strict limitations on temporary protected status, a humanitarian program by which the U.S. helps other countries devastated by war or natural disasters, and the list goes on. This is Trump's Mass Deportation Act. It is designed to cleanse the United States of undocumented immigrants. This bill will do nothing to address the existing backlogs for green cards. The bill does nothing to resolve the status of people who are undocumented in our country. The bill does nothing to resolve the daily limbo of DACA recipients who do not know when they, too, might be rounded up. This bill is a massive buildup and militarization of deportation forces and detention facilities. This bill will split families apart. It will undermine community safety. It will make our communities less safe. It will undermine our humanitarian leadership in the world, and it will force Congress to spend billions and billions of dollars on immigration enforcement and detention. I hope that this committee will scrap this bill and get to work on a bipartisan solution to resolve the problems in our nation's immigration system. But I hope that when we do it, we move forward on one that respects immigrants, not a deportation bill that demonizes them. Thank you, Mr. Chairman. I yield back the remainder of my time.
Thank you. The gentleman yields back. Do any other members seek recognition? If not, are there any amendments? Are there any amendments? Anyone seek for an amendment? The ranking member is recognized for a purpose of offering an amendment.
I have an amendment at the desk.
Excuse me, just one moment. They don't have any amendments at the desk, so. The gentleman will withhold for a moment. Here come the amendments.
Mr. Chair? Mr. Chair?
I'm not sure where it's coming from. Yeah, the gentleman.
I reserve a point of order. We haven't seen these amendments.
All right, the gentleman reserves a point of order. Thank you. The clerk will report the amendment.
Amendment to H.R. 2431 offered by Mr. Conyers. Strike Title I and redesignate provisions and amend the table of contents accordingly.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. It's strike Title I.
Mr. Chairman,
The gentleman already reserved a point of order.
and I withdraw my point of order at this time.
Point of order is withdrawn. The gentleman can proceed.
Mr. Chairman and my colleagues, this amendment would simply strike Title I of the legislation because H.R. 2431 represents a step backwards in our nation's effort to reform our immigration system. And Title I is one of the most troubling parts of the bill. First of all, Title I repeats a history of failed policy proposals. Past history has taught us that an enforcement-only approach will not fix our nation's broken immigration system. It never has. Despite this, Title I ignores common sense immigration reforms and simply seeks to expand the unnecessary arrest, detention, and deportation of millions of immigrants at an enormous cost to our nation. This same title also imposes an anti-immigrant agenda on states and localities across the country. The hallmark of our great nation is the belief that states have the right to make decisions for their own communities, particularly as it relates to decisions of public safety. Title I, however, overrides the good judgment of local officials and penalizes those communities that have decided to implement community trust policies. By imposing an anti-immigrant agenda on states and localities, this legislation completely ignores the judgment of chiefs and associations around the country who have long opposed turning police into immigration agents. As Riverside Police Chief Diaz said about a former version of this bill, You might have noticed that these kinds of laws, like 2278 and Arizona's 1070, don't originate with police chiefs. We're not asking for this kind of direction from legislators. We know that these laws will make crime worse and not better. So finally, Title I requires the federal government to expend billions of dollars unnecessarily detaining individuals such as dreamers and veterans who pose no threat to public safety. Under these provisions, the federal government would be forced upon request to assume custody of every person who a state or locality identifies as inadmissible or deportable. As a result, the government would be forced to expend billions more constructing more detention facilities to imprison individuals who pose no public safety threat. While I oppose this bill in its entirety, it's Title I that is particularly egregious. It threatens public safety, runs contrary to the basic principles of community policing, and would encourage racial profiling and unconstitutional arrests and detentions around the country. And so for these reasons, I urge my fellow members of this committee to support my amendment. I thank the chair and yield back the balance of my time, if any.
Thank you. The gentleman yields back. The gentleman from Idaho is recognized.
Mr. Chairman, I strongly oppose this amendment as it seeks to strike the most crucial provision of the bill, Title I, which ensures that state and local law enforcement can participate. I want to make this clear because we're going to hear this again and again and again. Nothing in this bill requires localities to do anything. It just gives them the authority to do something about immigration enforcement, and ensures that the state and local law enforcement can participate in the enforcement of our immigration laws. Is designed to ensure that our immigration laws not go largely unenforced at the whim of any president. The bill adheres to the Supreme Court's requirements in Arizona versus U.S. and grants states and localities specific congressional authorization to enact and enforce their own immigration laws. They may enact criminal and civil penalties that penalize conduct prohibited by criminal and civil provisions of federal immigration law, as long as the penalties do not exceed the relevant federal penalties. The bill also provides that law enforcement personnel of states and localities may investigate, identify, apprehend, detain, or transfer to federal custody aliens in the United States for the purposes of assisting in the enforcement of the immigration laws of the United States. Without the assistance of state and local law enforcement, we have no mechanism to ensure that the immigration laws will be enforced despite another unwilling administration. This amendment also strikes other important provisions in this bill. It would strike the provision that DHS may not refuse, absent a compelling reason, to enter into 287G cooperative agreements at the request of states and localities who want to assist in the enforcement of federal immigration laws. It would strike the provision providing grants to local law enforcement agencies that assist in immigration law enforcement. It would also strike the provision aimed at ensuring that sanctuary cities may not take into custody and subsequently release removable aliens already in DHS custody. And it would also strike provisions creating a federal cause of action for the victims of crimes committed by aliens who were only on the streets because a state or a locality refused to honor a detainer. I want you to listen closely to the opposition to this bill. They believe that enforcing the law threatens public safety. That is the most preposterous and outrageous argument that I have ever heard, and I think it's time that we start enforcing immigration laws. If we want a comprehensive approach to immigration, the number one step has to be that every American, the 300 million plus Americans, feel safe and secure, so we should put them first ahead of the 11 million that are here illegally. And I think that's the only way that we're going to have a true modern immigration system, and I urge my colleagues to oppose this amendment. And I yield back. Does the gentleman from New York seek recognition?
Strike the last word on the amendment.
Gentleman is recognized for 5 minutes.
Mr. Chairman, I strongly support the amendment. There are many, many problems with Title I of the bill, some of which the distinguished ranking member has listed, but let me mention a couple of clear constitutional problems. Section 108 of the bill turns the immigration system on its head by requiring the federal government to assume custody upon request by a state or locality over persons suspected by state or local officers to be a removable alien. So the federal government must imprison people suspected of being removable aliens. Whatever happened to due process? How can you imprison someone, how can you detain people suspected of being undocumented people? The government, upon request, would be forced to assume custody of every person whom a state or locality identifies as inadmissible or deportable. With what due process? With what process at all? It's problem number one. That is clearly unconstitutional. And just to take another unconstitutional provision of the bill, of the title, Section 114 attempts to commandeer state and local governments to comply with immigration detainer requests and threatens to withhold critical law enforcement funding to any locality that fails to comply with such requests. So in other words, the federal government could request through immigration detainers that state and local governments detain people. That seems a violation of any number of Supreme Court decisions that have said the federal government may not commandeer the resources of a local government. If the federal government wants to detain someone, it can, provided it has the proper evidence and goes through due process, but it cannot tell the state to do so. It cannot tell the state, you must devote your resources. You may think it's more important to spend more money on fire protection or on police protection against domestic violence or against armed robbery or whatever, but we're telling you no. You have to spend this money not on your priorities, but on enforcing federal detainers, because we don't want to spend federal money or enough federal money on enforcing a federal detainer. Now, in the Affordable Care Act case, Justice Roberts, for instance, threw out, not Justice Roberts, the majority of the court said that the expansion of Medicaid, the mandatory expansion of Medicaid in all 50 states to people not covered by it, even though the federal government was going to pay the cost of it, 90% of the cost of it, was unconstitutional because the federal government could not commandeer, among other reasons, that was one of the reasons, could not commandeer the resources of the state. Here, and therefore it became voluntary upon the states agreeing. Here, you're commandeering the resources of the state for a purpose the federal government determines to be more important than every other purpose of the state. So just in these two provisions, in addition to most of the bill and certainly most of this title being obnoxious on the merits, it's clearly unconstitutional. So I support the gentleman's amendment to strike the title, and if in fact this title is the heart of the bill, we ought to strike the bill too. I yield back.
What purpose does the gentlewoman from California seek recognition?
To strike the last word?
Gentlewoman is recognized for 5 minutes.
I very much support Mr. Conyers' amendment. There are defects in other parts of the bill, but Title I has many, many defects. And I'll just direct your attention to page 5, line 5, actually line 1 through 6, which basically authorizes the enactment of immigration laws by states and localities, and so provided that they're consistent with Section 101A.17 of the Immigration Nationality Act. What is that section say? It basically says immigration laws includes this chapter, which is the whole thing, plus all conventions and treaties of the United States. So we're actually inviting cities to enact their own immigration laws so long as they think they're consistent with an enormous body of law. This is directly contrary, really, to what the Supreme Court found was reasonable in Arizona versus the United States, where in that case, the court explained that federal control over immigration law is crucial because it's fundamental that foreign countries concerned about the status, safety, and security of their nationals in the United States must be able to confer and communicate on this subject with one national sovereign, not 50 separate states. By allowing every state or locality to enact their own immigration laws, foreign countries would be forced to confer and communicate not just with 50 states, but with thousands of cities and counties. It's a problematic provision and probably unconstitutional. I'd like to note also, and I put into the record a really very thoughtful analysis of this bill by the Cato Institute, and in fact, it was written by Mr. Labrador's former assistant, who we worked with when we had our working group doing immigration reform. The Cato Institute points out that although the bill purports to make us safer and to be consistent with federal-state relations, to empower state and localities, the main thrust of the bill actually is the opposite. Section 114 says unequivocally that the states and municipalities cannot create policies that decline to cooperate fully with the federal enforcement, but it goes on to ban policies that restrict state and local authorities from reporting unauthorized immigrants. And the weird thing is, it would essentially allow individual officers to make determinations, as pointed out, on some very arcane areas of the law, including obscure areas of labor law, and then act upon them, and state legislatures would have no capacity to actually control the officers within their own states to make sure that state policies were being adhered to. The immunization of a local officer who chooses to make arrests if they state they're acting under federal authority really does a very weird thing. We have a whole line of cases essentially stating, and Mr. Nadler referred to it most recently, the threat to force commandeering through the threat of withholding funds. You cannot commandeer state and local government to enforce federal law or to do the federal government's job, nor can you threaten to withhold funds to force states and localities to do what you could not otherwise force them to do directly. What this bill does is actually force the federal government to do what states want to do or what localities want to do. So if a law enforcement officer has a belief that an individual has violated an obscure area of immigration law or labor law related to immigration law and make an arrest, they've got to require the federal government to come and take that person. It's a very weird mix-up of the relationships between federal and state law, and I believe that there are many provisions in this act that are obviously unconstitutional. So in addition to my objection to this bill based on the impact it would have on people who have been here for many years, who have contributed to our economy, children brought here as infants who've done nothing but go to school and become as good a people as they possibly can, it also has serious legal deficits and Mr. Conyers' amendment should be approved. And with that, I see my time has expired. Mr. Chairman, I yield back.
Time of the gentleman has expired. For what purpose does the gentleman from Arizona seek recognition?
Strike the last word.
The gentleman is recognized for 5 minutes.
Thank you. I rise in opposition to the proposed amendment, and I want to just make a comment on some of the things I've heard because I'm in support of the bill as it is without this particular amendment. The first thing that comes to my mind is that in about the year and a half before that period of a year and a half before I was elected to this position, in Maricopa County, where I am from, Maricopa County, Arizona, more than 10,000 criminal aliens were released onto the streets of that county. 4.5 million people, but releasing known criminals onto the streets who are in this country illegally. Of those, more than 3,000 of them were known to be criminally violent, it was reported. That is to say, they had been charged with rape, with murder, with felonious assault or aggravated assault in Arizona. That doesn't mean everyone who crosses the border illegally is a violent criminal, but in this instance, those violent criminals were released onto the streets of Phoenix and the Valley of the Sun. One of those who was released, who had been deported twice and made his way back into the country, wandered into the QT market in Mesa, my district, and on that particular early morning decided he wanted a pack of cigarettes and didn't want to pay for it. And he, who otherwise should not have been in this country, pulled his gun out and shot this young man, Grant Ronnebeck, at point-blank range between the eyes and killed him. That's devastating. This bill would have required him to be held in custody. Brandon Mendoza, a little over a year ago, a Mesa City police officer driving on the freeway was hit by someone else who was in this country illegally, who was drunk and hit him head on going wrong way on the freeway. So these are just a couple of the incidents that have happened in my district over the last couple of years. And so I bring the support of millions of Arizonans who've watched for decades the impact of illegal aliens' presence who are here committing crimes. I bring the support of the family of Rob Krenz, an Arizona border rancher who was killed by illegal aliens. And I point out that in Section 105D, Section 108C, and Section 109C of this bill, there is reimbursement provisions for local jurisdictions. I oppose this amendment. I support the underlying bill without amendment, and I yield back.
Would the gentleman yield?
Yes, I'll yield.
I thank the gentleman for yielding. I appreciate very much his remarks, and I know as a representative from Arizona, you're familiar with Arizona versus the U.S. In that case, the Supreme Court ruled very clearly that states could enact immigration enforcement provisions provided that they were in compliance with the immigration laws of the United States, and also made it clear that they could participate in a 287G program, which the Obama administration then, I think the very next day, kicked Arizona out of. So if we're trying to get better cooperation between state and local law enforcement and federal law enforcement to properly have respect for the rule of law and enforce our immigration laws, it would seem to me that that would be a good thing to require that the federal government have to show good cause for eliminating an entire state from an important program that adds considerable resources and manpower to supporting the law.
Yes, I'll reclaim my time. Yes, Mr. Chairman. And in fact, the law enforcement agencies, not necessarily the chiefs of police, but the law enforcement agencies wanted to continue participation in 287G programs, but without cause, had that opportunity taken away and stripped away from them by the Obama administration. That's correct.
I thank the gentleman for yielding. For the purpose, the gentleman from Rhode Island seek recognition.
I move to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I would first say I strongly support the gentleman's amendment. But I have to say, Mr. Chairman, I asked to be on the Immigration Subcommittee because I hope that we would have an opportunity to actually address our broken immigration system and have hearings on a proposal to do that. We're now taking up for markup a 184-page bill that we've never had a hearing on before the Immigration Subcommittee or this full committee. That's really not a good way to do business and not a way to tackle such a complicated issue. The sponsor of this bill said at the opening of this hearing that we're the greatest nation in the world. There's no question about that. But this legislation, I would suggest to you, undermines that claim. It reverses long-settled law. It threatens civil liberties. It undermines our nation's history as a land of immigrants. It violates our Constitution, and it criminalizes human beings. Let's call it what it is. This is President Trump's Mass Deportation Act. And it is based on a notion that immigrants endanger our lives. And I can tell you, Mr. Chairman, members of the committee, I know from my own experience in my great state that immigrants have added so much to Rhode Island. Entrepreneurs, educators, elected officials, police officers, and on and on and on. Made enormous contributions to our state. And I understand, as all members of this committee do, that we have no more sacred responsibility than to keep the American people safe. And this legislation undermines that responsibility because it's based on a faulty premise that immigrants are more dangerous. And in fact, the presence of immigrants endangers our lives. And I'd like to submit for the record a compilation of 11 studies that directly contradict that assertion, that in fact show there is either no link between immigration status and criminality, or in fact less likelihood that those who are in fact non-citizens are less likely to commit crimes, and the accompanying reports that support those.
Without objection, would the gentleman yield?
And I won't, Mr. Chairman, only because I don't have very much time.
All right.
This is based on a faulty premise. You can't make stuff up to support a bill. And the notion that people who are undocumented are more dangerous is simply not true. This bill criminalizes all undocumented immigrants, including the dreamers. It undermines public safety, and it will waste millions of dollars of taxpayer money. It allows states and local communities to enact their own immigration laws and the chaos that will ensue from that. And it also will turn everyday police officers into the immigration police. It overturns Supreme Court precedent by allowing the Department of Homeland Security to detain immigrants permanently if they are unable to be removed to their home country. Think about what that does to the founding values and the important principles of our country. And of course, it triples the number of ICE deportation officers and arms all of those officers with military-grade equipment. It's not hard to see how this was on Steve Bannon's whiteboard, but it is hard to see how it came before this committee without a hearing and with such a faulty premise. It is the reason, in fact, that so many law enforcement officers have come out against this bill, because those individuals charged with keeping communities safe recognize it undermines their ability to do that. This bill not only makes our communities less safe, but it really does change and will change the very character of our country. We are better than this. We ought to be enacting comprehensive immigration reform that will honor our responsibility to the Constitution, that will in fact keep our communities safe, and that will respect the great tradition of our country to welcome immigrants from all over the world and to recognize that immigrants have made us more prosperous and stronger and a better country. Frankly, Mr. Chairman, the presence of this bill before this committee makes me very sad. We are better than this. I urge all of my colleagues to support Mr. Conyers' amendment to defeat the underlying bill, and I yield the balance of my time to the chairman. Mr. Chairman, I'm yielding to you.
I'm actually going to recognize the gentlewoman from
Okay.
Alabama. For what purpose do you seek recognition?
I move to strike the last word.
Gentlewoman is recognized for 5 minutes.
I'd like to yield my time to the chairman.
I thank the gentlewoman for yielding. I just want to say in response to the gentleman from Rhode Island, we're a nation of immigrants. There's not a person here sitting on this committee who can't go back a few generations or several generations and find someone in their family who immigrated to the United States. But we are also a nation of laws. And when we go for years and years and years without enforcing those laws, the lack of respect for the rule of law only grows. This is simply a bill that gives any administration, the current one and future ones, the authority to enforce our laws properly, and gives to state and local governments that are heavily impacted by illegal immigration the ability to participate in that enforcement. There is nothing other than a dignified approach to making sure that law enforcement has the tools to enforce these laws. And the underlying purpose of this bill is not to disrespect immigrants, most of whom have entered the United States legally, because the United States has the most generous legal immigration programs in the world, but it is to make sure that we respect the rule of law. Yes, many people who are here illegally don't commit additional crimes, but the very act of entering the country illegally is a crime. And when you enter the country legally and overstay, well, guess what? You can't be detained under current law because you haven't committed a crime. So we add a misdemeanor provision to make sure that those individuals can be properly detained until they're safely removed to their home country where they belong. I thank the gentlewoman for yielding, and who seeks recognition.
I would like to yield the remainder of my time to Mr. Labrador.
I was really actually pleased to hear Ms. Lofgren mention my talented former staffer, David Beer. He's was one of my favorite staffers and one of the smartest people that I've worked with in the past. But he and I often disagreed on immigration policy, and we had some really fun debates about that. I should also mention that Ms. Jackson Lee's former staffer, Nolan Rappaport, has published a number of pieces recently defending the constitutionality of President Trump's actions to protect our nation and enforce our immigration laws. Nolan is also a very talented attorney, and I would like to ask unanimous consent that his articles be placed in the markup for the record.
Without objection, they will be made a part of the record.
Okay, and I just want to take this opportunity to address our broken immigration system. It's ironic to hear the people from the other side continues to say that they wish we could do something on our broken immigration system. I've been here for 7 years. We passed legislation out of the House, some of it with support from our friends on the other side, that the Senate would never take up because it wasn't the comprehensive approach that they wanted. These were good pieces of legislation that address specific parts of the immigration system, specific parts that we all know are broken, and I commend my friends on the other side who joined us in passing that legislation, but because the previous president and the Senate Democrats did not want to have a step-by-step approach, they refused to even fix those small parts of the immigration system. And that's why we continue to have a broken immigration system, because some people choose to use immigration as a political tool instead of fixing the problems that we have. One of the main problems that we have is the enforcement of immigration laws. I think it's the first step in making sure that we fix the entire immigration system. I remember sitting down with countless people who were here without documentation when I was an immigration lawyer. And I would ask them a simple question: why did you want to come to the United States? What forced you? What compelled you to make the move to come to the United States? And they all said universally the same thing. I live in a country, or I lived in a country, where the laws were not enforced adequately, fairly, or honorably. And I want to live in the United States because I want to live in a country where the laws are enforced. And yet, the people on the other side don't want that tradition that we have in the United States to continue. They want some laws to be enforced and other laws not to be enforced. That's why I'm a strong proponent of this bill, and that's why I believe that if we pass legislation like this, where the 300 million plus Americans feel safe and secure in their land, in their homes, in their communities, then we will have the guts to actually do what's necessary to fix the immigration system that we have and to modernize it. And for that reason, I think we should all actually be voting for this and not have the debate that we're having right now, whether we should or should not enforce the immigration laws of our land.
Chair thanks the gentleman. The question occurs on the amendment offered by the gentleman from Michigan. All those in favor respond by saying aye.
Aye.
Those opposed, no. Opinion of the chair, the noes have it. The amendment is not agreed to.
Record vote, please.
Board vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. King? Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Gowdy? Mr. Gowdy votes no. Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Collins? Mr. DeSantis? Mr. DeSantis votes no. Mr. Buck? Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson of Georgia? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye.
The gentleman from Arizona, Mr. Franks.
Mr. Franks votes no.
Gentleman from Texas, Mr. Poe.
Mr. Poe votes no.
Gentleman from Texas, Mr. Gomert.
Mr. Gomert votes no.
Gentleman from Pennsylvania, Ms. Marino.
Mr. Marino votes no.
Gentleman from Iowa, Mr. King.
Mr. King votes no.
Gentleman from Colorado, Mr. Buck.
Mr. Buck votes no.
Gentleman from California, Mr. Issa.
Mr. Issa votes no.
The gentleman from Texas, Mr. Smith.
Mr. Smith votes no.
The gentleman from Georgia, Mr. Johnson.
Mr. Johnson votes yes.
Has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, 9 members voted aye, 18 members voted no.
And the amendment is not agreed to. Are there further amendments? For purpose, gentleman from New York seek recognition.
The amendment of the desk.
The clerk will report the amendment.
Amendment to H.R. 2431 offered by Mr. Nadler. Strike Section 314 and redesignate provisions.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
What? Mr. Chairman, this amendment would strike Section 314 of the bill, which makes it a crime to be unlawfully present in this country. Under current law, the act of being unlawfully present is a civil violation, not a criminal one, and it is not punishable by imprisonment. This bill, however, would turn millions of Americans into criminals overnight. Under this bill, if you overstay your visa for 1 day, you could go to prison for 6 months. For a second violation, you could face a 2-year sentence. A lot of tourists, a lot of people whose airplane flights got canceled would suddenly be criminals. And if you have a prior felony conviction on your record, even a nonviolent drug offense, you could serve as many as 20 years in prison. This provision even applies to dreamers who were brought to this country as children through no fault of their own, and who, once they turn 18, would now be considered criminals facing imprisonment if they know they are here unlawfully. This is both inhumane and counterproductive. Unfortunately, it follows directly from the underlying assumptions that pervade this entire legislation: that immigrants are dangerous, that they are to be feared, that their lives must be made as miserable as possible, and that they must be removed from this country no matter who they are or how long they have been here. This bill is straight out of the Donald Trump mass deportation playbook. First, you demonize immigrants. You blame them for crimes, even though they commit crimes at a lower rate than native-born Americans. Then you demonize them. Then you label them all as criminals, all of which helps you build public support for removing them all from the country. Americans are rightly resistant to deporting their neighbor, their coworker, a member of their church, or someone who has been a member of their community for years. Most people recognize the cruelty involved in ripping families apart, and they see no reason to remove people who have been here for years and who are pillars of society. But if you label undocumented immigrants as dangerous criminals, if you throw them into prison, and if you turn them into felons merely because of their presence in this country, you can then argue with somewhat more apparent plausibility that they are a danger to society and they must be removed regardless of the facts. When you combine this provision with the mass deportation force that this bill and the Trump administration envision creating, we would force millions of immigrants further into the shadows. And in doing so, we would become less safe, since no undocumented immigrant would ever consider cooperating with law enforcement if they risk significant prison time should their status be discovered. Even victims of domestic violence who need protection from their abusers, or witnesses to serious crimes or even murder, would stay silent out of fear that they could be deported if they came forward with their testimony. Study after study shows that immigrants are less likely to commit serious crimes than native-born Americans. In fact, a 2017 study by the Sentencing Project found that higher levels of immigration in recent decades may have contributed to the historic drop in crime rates. But this bill ignores those facts in favor of its own alternative facts. And I want to say, I think one of the most shameful things that this president has done was to take victims of crimes and have them in the gallery during the State of the Union address to pretend, victims of crimes committed by undocumented immigrants, to pretend that undocumented immigrants were a particular menace to Americans to commit violent crimes, when all the information we have says just the opposite. But this bill ignores those facts in favor of its alternative facts. If you can't argue that immigrants commit more crimes, you can just turn all undocumented immigrants into criminals. That's what this bill does. I urge my colleagues to oppose the politics of fear and to support my amendment. I yield back the balance of my time.
What purpose does the gentleman from Idaho seek recognition? Mr. Chairman, to strongly oppose this amendment.
The gentleman is recognized for 5 minutes.
This provision addresses the civil penalties, that addresses the issue that we need to have a deterrent on what's happening with immigration. 40% of the unlawful aliens in the United States are overstayed. And we have heard that figure again and again and again. This is a crucial provision to ensure that ICE can arrest, prosecute, and actually deter illegal immigration. Illegal entry into the United States has long been a federal misdemeanor offense. The SAFE Act simply provides that, this act simply provides that illegal presence in the U.S. is also a misdemeanor. The majority of unlawfully present aliens in the U.S. enter the U.S. illegally and therefore have already violated federal criminal law. The minority of unlawful aliens who have abused our hospitality and overstayed their visas are just as culpable as aliens who have entered the U.S. illegally. Why are we treating people differently? If you entered illegally or just overstayed your visa, you should be treated the same. If we want to empower state and local law enforcement, this provision is a necessity. A federal court has ruled that state and local law enforcement officers cannot detain persons on the basis of being unlawfully present in the U.S., and we're just giving them the tools that they are necessary for us to enforce our immigration laws. And for that, with that, I yield back.
What purpose does the gentlewoman from California seek recognition?
Mr. Chairman, I very strongly
Gentlewoman is recognized for 5 minutes.
move strike last word. I very strongly support Mr. Nadler's amendment. As Ms. Jayapal explained, I thought very cogently, it is not a violation of criminal law to just simply be alive in the United States without your visa papers being in order. This would change that and make that status a crime. The author suggests that the rationale is to also deal with overstays who, the entry of which is not a criminal offense. But the truth is that this would have far-reaching implications. I remember years ago when the House took up a bill to make it a felony to be alive without your papers, and there was a tremendous disagreement all over the United States. It was later, a discussion of making it a misdemeanor. There's no time limit. If you, as mentioned, I think by Mr. Nadler, if you are here on a temporary visa and you have a minor overstay, really even, your plane is late, theoretically, you would be in commission of a misdemeanor. Now, the argument could be that that wouldn't be prosecuted. In fact, we've seen a recent instance where an individual who missed their plane was arrested for visa overstay. So I don't want to be comforted by the idea that law enforcement people would not go crazy. But committing an offense also precludes certain other immigration benefits. So that if you marry an American citizen, but you have committed an offense, you're excludable and may not be able to gain the status that your marriage to an American citizen would otherwise grant. I don't know that that's the intent of the author, but I think that would be the result. It's worth pointing out, we just took up a bill earlier in the day about trafficking victims. And we've always had, a very strong effort to work on a bipartisan basis with trafficking victims. But if you look at the way this is crafted, people who are victims of trafficking, but who have not yet obtained a visa that we've provided for earlier in the trafficking victims laws, would also be in a criminal law status. That can't be what we have in mind here. I think it's important to know that asylum applicants, and American law provides for asylum, international law provides for asylum. If you were unlawfully present even for one day and then applied for asylum, you would have a misdemeanor bar. Possibly you could be prosecuted. I don't think that's what we want to do. And finally, as it has been mentioned, this bill would criminalize current DACA recipients over the age of 18 who has a lapse in DACA benefits. I think that is a terrible mistake. I know that not everyone agrees that babies, people who are brought here as babies who didn't intend to enter unlawfully or to stay beyond the visa should be protected, but certainly those individuals as young adults are in a different situation than others, people who have, in many cases don't even find out that they're not American citizens until they go to apply for a loan or some other thing that, as their friends in high school are doing. I think also, I'm sorry that Mr. Gates is not here, because I remember years ago we had a hearing about how did people end up in an undocumented status in the United States. And we have had a system that doesn't work for a long, long time. And I always remember the president of the Southern Baptist Convention testifying that for many years we had two signs at the southern border, and one sign said no trespassing, and the other sign said help wanted. And a lot of people responded to that help wanted sign. In fact, most of the farm workers of the United States responded to that help wanted sign. There is no way, we have 5,000 visas allocated a year to people who are supposedly in the unskilled labor category. We have 2 million farm workers. Clearly, we set this situation up, and to tell those farm workers that they're now also criminals, I think is well beneath our dignity as a Congress, and this amendment would fix that, and I yield back.
Mr. Chair.
What purpose does the gentleman from California seek recognition?
Or Maryland.
I was looking at California, he was seeking recognition too, but, oh, I'm sorry, you're right, okay, well, since I was wrong on both of you, I'll go to the gentleman with seniority, that's the gentleman from Maryland, so.
Mr. Chair, thank you very much.
Gentleman's recognized for 5 minutes.
Move to strike the last word. I should start just by saying that I'm influenced by my own personal experience in discussing this because very briefly, I was an illegal immigrant or an undocumented immigrant in France. I went over on a sabbatical to teach there, and I was instructed to go immediately to pick up my academic visa on a Friday. And when I got there, it turned out that the people at the immigration office were on strike, so I couldn't get my credentials, my academic visa, over the course of the weekend. And then when I showed up the next week, there was such a huge crowd, I couldn't even get a ticket, much less get my ticket called. And this went on for about 2 or 3 weeks, during the period of which I was growing increasingly anxious about my status because I was there with my whole family and I didn't have the proper academic visa credentials. And that was without knowing or learning or suspecting that I was a criminal at the same time, as opposed to just being running afoul of the civil immigration provisions. So I think we've got to think very seriously before we do this, what it means to tell people, and we're talking about millions of people whose immigration status could change on a diplomatic visa, an academic visa, a tourist visa, or what have you, that suddenly they're a criminal in the United States. Remember, America was created as the country for the whole world. Tom Paine called it a haven of refuge for people seeking political or religious refuge from tyrants and from oppressors all over the world. And this is who we are as a country. This is why our symbol is the Statue of Liberty. It's not a wall surrounded by barbed wire and a moat and alligators. This proposal, or the amendment rather, would alter a proposal to turn every person who is unwillingly and ever so briefly outside of the regulatory demands of the immigration system into a criminal. And this creates what the Supreme Court has called a status offense. The Supreme Court has rejected numerous status offenses as a violation of due process, like statutes that say someone is guilty of a crime by being an habitual drunkard, or someone is a criminal because they are a drug addict, or a vagrant, or a loiterer. Under our system of laws, people are guilty of committing crimes, having an actus reus, a real criminal act, and a mens rea, a criminal intent, an evil intent. And the proposal in the bill would turn someone into a criminal without either a criminal act or a criminal consciousness, a mens rea to do something criminal. It creates a pure status offense that is based in many cases, not all of them conceitedly, but in many cases, simply on inaction or someone else's action completely out of the control of the person who becomes the criminal defendant. So I would think that this goes way too far in terms of the basic principles of due process and legality and criminal notice in our system of laws. And people should think about it. This could happen to anyone. And I'm sure that every person in this room, and I'm following our distinguished chairman here and saying that all of us come from families that originally were immigrants. I also believe that we could find in all of our genealogy, in all of our family, somebody whose immigration status was not documented at some point. It would be almost difficult to find that. Let's at least not brand those people criminals, and let's not brand people in America who, as criminals who do not meet in any common sense interpretation our definition of what a criminal is.
Gentleman yield?
Yes, by all means.
Gentlemen, you made the point, and I think the valid point, that this establishes a crime of status because you're here illegally. In effect, the crime occurred 10 years ago when you came here illegally, or when you, if you were a dreamer, when you hit your 18th birthday. Would this implicate the ex post facto provision of the Constitution? Because it's saying you're a criminal now for an act that you did years ago when you overstayed your visa?
Well, let's distinguish a couple different cases. I mean, one case would be where someone originally had legal status, someone who had a visa, and it lapsed, and the office was closed. There was a blizzard or something, and they weren't able to get it renewed on that day. That would clearly be a status offense. In the case you're talking about, where something's turned into a crime retroactively, that also arguably runs afoul of the ex post facto clause.
Thank you.
Time of the gentleman has expired.
Go
For
back.
purposes, the gentleman from Pennsylvania seek recognition.
Strike last word, but I'm
Gentleman's
going to yield
recognized
to
for
my
5 minutes.
colleague, Mr. Labrador.
Well, I just want everybody, thank you, Mr. Marino, thank you for yielding your time. I want everybody to read section 314, because that was a compelling argument unless you read the actual statute. And the actual statute says that knowingly enters, knowingly eludes, knowingly enters or crosses the border, knowingly violates the terms or conditions of the alien. So what you did in France was not a crime under this bill, because what you did in France is you actually had the intention of being legal. You went again and again and again to try to become legal. So you would have never violated this statute. That's number one. Now, that was also a great disposition of ex post facto law, but that would only be true if it's applied retroactively. This is what we're trying to do, is prevent future
Gentleman yield?
illegal immigration and future exposure of our immigration laws.
Gentleman yield?
So
Could I get one question first, if the gentleman would
it's
yield?
not my time, so
Good.
if he will yield to you.
Yeah, I just want to, would the gentleman yield just for a question? Was that okay?
He said it's not his time.
Thank you. So, as I'm reading it, knowingly violate would describe the situation of somebody in the same situation I was in France, because I was aware that I didn't have my documents. I desperately wanted to get my documents. I was not there to be committing crimes, obviously, except for my students, because they had to hear my broken French. But other than that, I was there for lawful purposes, but I knew I was outside of the law. And I think, I mean, if what you're saying is that one should have to knowingly try to subvert the laws, that's great. But this is knowingly violate the laws, and I assume that I knew I was in violation of the laws, and I was desperately trying to get out of that situation.
And I think if we have any other person who's desperately trying to become legal and trying to keep the law, they're not going to be prosecuted under the statute.
Oh,
But
I think most of them are.
But and that's the way it is. Yeah, most of them are trying to become legal, but they don't have a right to be in the United States. But I do want to address something that the gentlelady from California said, and I think she made some good points. We don't want anybody to be found to violate the law because of just all of a sudden they had an oversight, or they just had a couple of days of overstay. So I am going to be looking, as we continue with this bill, to fix this section of the bill to make sure that we don't have just somebody who had a couple of days overstay violate the law. So I will be working on that.
The gentleman yield?
Yes. Well, it's not my time. Yes.
Thank you. I thank the gentleman for his second grade yielding.
Yeah.
Second derivative yielding. What you said a moment ago, which is that you have to knowingly elude, et cetera, that's subsection or subparagraph, whatever, B. But if you read subparagraph E, it says, 1, an alien shall be subject to the penalties set forth in paragraph 2 if the alien, E, knowingly is unlawfully present in the United States, subject to the exception set forth, et cetera. Knowingly is unlawfully present. Now, he is present in the United States because 10 years ago he overstayed his visa, and he suddenly becomes a criminal by ex post facto application of this bill.
I think the ex post facto aspect of this will be determined by the courts. You cannot, we all know what ex post facto law is.
And this seems to be a clear case of it.
I just completely disagree with you on this matter, but we will continue to try to enforce our immigration laws, and I yield back my time.
Mr. Chairman,
For purpose of the gentlewoman from Washington, seek recognition.
move to strike the last word.
Gentlewoman's recognized for 5 minutes.
Thank you, Mr. Chairman. I rise in strong support of this amendment, and I thank Mr. Nadler for putting forward, I think, an extremely important amendment that would strike one of the most disturbing parts of this bill. This bill would, what is proposed in this bill is really no minor adjustment. It represents a radical transformation of United States immigration law. For over a century, unlawful presence in the United States has been, as Mr. Nadler said, a civil infraction of immigration law, meriting at most removal. And if enacted, this act would turn that civil infraction into a crime punishable by as much as 20 years of imprisonment. It is impossible to know how many of the 11 million or so people who are currently in the United States without the federal government's permission could be prosecuted, but it's safe to assume it would be an enormous number of people. And I think that we have to also think about why law enforcement has come out consistently against these kinds of proposals, because it would actually draw resources away from really focusing on the most needed criminals who and the work that local law enforcement should do. But I wanted to back up a little bit, because there have been a lot of things said on this committee today about this nation as a nation of laws, and certainly that's true, and we all want to make sure that we continue to be a nation of laws. But I must also say, in the words of Dr. King from the Birmingham jail, that an unjust law is no law at all. Slavery was also the law of the land, but there were many people who sought to change what were, at that time, extremely unjust laws. And that, in my opinion, is the case in terms of immigration law. The reality is that the number of immigrants that are allowed into the United States is set by Congress. But the last time that Congress asked to adjust that system was in 1990. So we have a legal immigration system that is broken. And I am one of the people that knows exactly what that means, because it actually took me 18 years to become a citizen of this country. I went through a whole alphabet soup of immigrant visas, and I believe there are about a dozen or maybe a little bit more members of Congress who were actually born outside of the United States. We understand what the immigration system is about, and I believe that almost every single immigrant in this country has really tried to follow a system that allows them to be here, because nobody wants to be here without papers. Nobody wants to be in the shadows. Nobody wants to be doing the work or providing for their family, knowing that every day poses a threat to their children or to their families. So the legal system is broken, and that is why we have sought consistently for decades to have a comprehensive reform of the immigration system. It's not enough just to pass one small piece of reform, because in fact, everything is tied together within the immigration system. And what we need is a comprehensive reform, because when the legal system is broken, we have to think about what choices we give to a mother who must wait sometimes for 20 years to get her child into the country. What choices do we give to a worker who is being sought after by companies and industries in this country because they're performing essential work that often others won't perform? What choices do we give to them to actually be able to do that work with dignity? And so that is why the US Senate in 2013 did pass a comprehensive immigration reform bill with 67 bipartisan votes. And that bill, unfortunately, was never allowed to the floor by Speaker John Boehner at the time. And had we had that bill, then we could have focused resources on just those immigrants who have committed the most serious, most heinous of crimes. We could have encouraged and recognized the dignity and the work of immigrants across this country who are doing the work that we need to do, and we could have made sure that families were reunified with a legal immigration system that actually encouraged people to be together with their children, with their parents, with their spouses. And that, Mr. Chairman, I think is the basis of what we need to be doing instead of putting forward bills that seek to simply otherize, vilify certain immigrants without recognizing that the underlying system is broken. So criminalizing 11 million undocumented immigrants across this country is not just inhumane, it doesn't solve any problem. And we need to find a real solution for our broken immigration system in this country. And I hope that our committee will actually take that on with the seriousness that it deserves. Thank you, Mr. Chairman. I yield back.
Mr. Chairman.
Time of the gentleman has expired. For purpose, the gentleman from Illinois seek recognition.
Thank you. I move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you. And I want to join with my colleagues in emphasizing, I think, the need to address this issue, as was noted earlier. The knowingly in this country in violation would consume essentially every dreamer who reaches the age of 18. The cruel legislation would criminalize nearly all undocumented people. There are no exceptions included in the bill, not even for these DACA recipients. This makes their presence in the country a misdemeanor or felony offense, exposing DACA recipients to criminal prosecution and possible imprisonment. Let me repeat that. This legislation makes the very presence of DACA recipients a criminal offense, putting these young people, young men and women, literally pursuing the American dream at very real risk of criminal prosecution and possible imprisonment. This is not a theoretical discussion. This legislation will have real, profoundly negative consequences for the communities we all represent. Let me share just one story, the case of one of my constituents, Erica. Erica works as a public health community liaison in schools throughout my district. After graduating high school, she worked to pay her way through college and graduated with honors. Now, while working full-time, she's also pursuing an MBA. She's very proud that she recently became a homeowner and enjoys volunteering with community groups. By any measure, Erica is an exemplary member of our community, a leader and a role model. Erica also happens to be a DACA recipient. She was just 13 years old when she was brought to the United States and has lived here for 23 years. The United States is now unquestionably her home. Her dreams and aspirations are American dreams. Her success strengthens our community and advances our nation. In 2013, Erica first applied for and received DACA. She describes the effect that this program had on her life, saying, "I've had two lives, before and after DACA." I met Erica when she contacted our office after a clerical error at USCIS delayed her renewal application for work reauthorization. Her HR representative at her employer informed her that she would lose her job if she could not get the reauthorization. This was but a brief glimpse into what her life would be like without DACA. She, and I quote here, realized how much is at risk, end quote. Erica would lose her job, her home, her driver's license, her health insurance, her ability to pay for her schooling and earn a living. In short, she and all others like her would lose everything. Erica is a tremendous asset to our community, but this bill would label her a criminal. No one like Erica, who came here as a child and has lived her entire adult life in the United States, should have to live in constant fear of deportation. This isn't just a matter of right and wrong, it's a matter of economics. The recent estimate by the Cato Institute found that deporting DACA recipients could deprive the United States of over $280 billion with a B, $280 billion in economic growth over the next 10 years. In other words, this bill will hurt DACA recipients and American workers alike. A 2016 survey found 6% of DACA recipients, more than 40,000 young people, had started their own small business in the United States. That's a rate of entrepreneurship twice as high as native-born Americans. Our immigration system is broken. I agree, and let's work together to address it. But this draconian bill is absolutely wrong and the wrong way to go about fixing it. What we need is comprehensive immigration reform, not a mass deportation approach. Real bipartisan reform, including increased responsible border security and a path to citizenship for those like Erica, will grow our economy and reduce our debt, and strengthen our communities. DACA recipients are not criminals. They are the products of our schools, part of the fabric of our communities, and important to the future growth and success of our country. I strongly urge my colleagues to join me in supporting this amendment, and I yield back.
Mr. Chairman?
There are 8 minutes and 25 seconds remaining in the vote on the floor. We will not be returning. The markup will continue next week. I would like to get to a vote, but if the gentleman...
If I can be recognized, I'd just like to yield briefly to Mr. Nadler.
Thank you, and I'll be very brief. I'd like to say that, following my argument before, page 103 of the bill, subsection 4, duration of offense. An offense under this subsection continues until the alien is discovered within the United States by an immigration, customs, or agriculture officer. In other words, it's a status offense. There is no statute of limitations, unlike any other crime that I know of except for murder. And someone who overstayed the visa 10 years ago now becomes a criminal ex post facto and remains a criminal, and there's no statute of limitations. A little excessive, and I'll yield to the gentlelady from California.
I would like to note, and I know that we all want to get to the floor, but the problems on this are severe, and if you take a look at page 101 of the bill, line 20, the exceptions do not include individuals who are victims of domestic violence but have not yet applied for their visa. They do not include individuals who are trafficking victims but who've not yet applied for a visa because of that victimhood. That can't be what we want. In addition to all the other arguments that have been made, that makes this really fatally flawed, and I thank the gentleman for yielding and yield back.
I yield back.
Question occurs on the amendment offered by the gentleman from New York. All those in favor respond by saying aye. Aye. Those opposed, no. Being the chair, the noes have it. Record votes. Request clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? No. Mr. Issa votes no. Mr. King? Mr. Franks? Mr. Gomert? Mr. King votes no. Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Jordan votes no. Mr. Poe? No. Mr. Poe votes no. Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Collins? Mr. DeSantis? Mr. DeSantis votes no. Mr. Buck? Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Conyers? Mr. Nadler?
No, I mean yes.
Mr. Nadler votes yes. Ms. Lofgren?
Aye.
Ms. Lofgren votes aye. Ms. Jackson Lee? Aye. Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Aye. Mr. Johnson votes aye. Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Aye. Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Raskin? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider?
The gentleman from Arizona?
Mr. Franks votes no.
Gentleman from Texas?
Mr. Gomert
The
votes
other
no.
gentleman from Texas?
Mr. Smith votes no.
Gentleman from Colorado?
Mr. Buck votes no.
Gentleman from Michigan?
Aye.
Mr. Conyers votes aye.
The gentleman from Illinois?
Mr. Schneider votes aye.
Has every member voted who wishes to vote? The clerk will report.
Mr. Chairman, 8 members voted aye, 17 members voted no.
And the amendment is not agreed to. The committee will stand in recess and will resume Tuesday.